Okay, sir. Okay. Thank you. Total 16 ಅಲ್ವಾ ಸರ್ ಇದು? Total 16 ಅಲ್ಲ?
ಹೌದು 16.
ಹಾ. ಸರ್ ಟೋಟಲ್ 16 ಇಂದ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಇದು ಬರ್ಲಿಲ್ವಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ. ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
ಓಕೆ ಸರ್. ಅದಾಕಿಲ್ವಾ? ಇಲ್ಲಿ ಬರ್ತಾ ಇಲ್ವಲ್ಲಪ್ಪ? ಏನೋ ಒಂದು ಮಾಡ್ತಾರೆ. ಇಲ್ಲ ಅದಕ್ಕೆ
ಟಿವಿ ಬರ್ತಾ ಇಲ್ಲಪ್ಪ, ಟಿವಿ ಬರ್ತಾ ಇಲ್ಲ
ಮುಂದೆ ಇದೆ.
ಏನು ಏಕೆ
Page wise adjournment. Sheet number 2, page number 1, serial number 1 to 4. Page number 2, serial number 5 to 8. Page number 3, serial number 9 to 30. Page number 4, serial number 14 to 18. Page
Your
number
Lordships
5.
kindly, with your Lordships kindly, my lord, serial number 16, my lord.
Yes.
My lord, this matter is connected with
Yes.
my lord, this appeal is connected with 5071/2020 by the claimant.
Yes, this appeal may be called along with the change. Yes,
Sir, 5071 of 2020.
Howದು.
Page number 5, serial number 19 to 24. Page number 6, serial number 25 to 31. Page number 7, serial number 32 to
One
34.
submission. My lord, serial number 24, my lord.
yes,
This matter is connected with MFA 24.
this appeal may be called along with the
5303/21.
530
3.
21. Yes.
Page number 6, serial number 25 to 31. Page number 7, serial number 32 to 34. Page number 8, serial number 35 to 38. Page number 9, serial number 39 to 42. Page number 10, serial number 43 to 48. Page number 11, serial number 49 to 54, 55.
My lord, serial
Page
number
number 12.
54, my lord.
Serial number,
My lord, serial number 54. Due to
Yes.
some personal arrangements, I cannot attend the matter, my lord. May kindly be taken up next week.
counsel for respondent.
54,
Next
my
week.
lord. Much obliged.
Okay.
12, serial number 56 to 61,
57 may be taken.
page
up
number
next week.
13.
I requested the other side. I requested the other side also informed. 57.
My lord, 61, my lord.
57, my lord.
Next week.
Next week. Yes.
My lord, 61, my lord. Kindly
Next
it may
week.
be taken up next week, my lord. 61.1, my lord.
You are appearing for?
Yes, Nirmal, appellant, my lord.
Yes. Why do you want?
Next week it may be taken up, my lord.
Some of our withdrawal of at the request of counsel for appellant. Release this one.
Much
Page number
obliged.
13, serial number 66,
Appellant in 61.
page number 4, serial number 67 to 72,
My lord, 71, my lord, after 2 weeks, my lord. Serial number 71.
71. At the request of counsel for respondent number 2. Release this matter of 2 weeks.
Okay.
68. Yes. At the request of counsel for the appellant next week.
With your lordship's leave, my lord.
Yes.
With your lordship's leave, my lord.
Serial number?
My lord, it is for posting for my lord correction, my lord. There is some error has occurred in the judgment which has been passed. MFA, my lord, 5149 of 2013.
Yes.
Some clerical thing, my lord, calculation mistake is there. May kindly be posted for being spoken to, my lord, for correction. Monday, my lord, Monday. MFA 5149 of 2013. my lord.
Yes.
page number 15, serial number 73 and 74,
My lords, I appear in serial number 74 for respondent number 1 to 3. Kindly grant me 2 weeks of time, my lords. I have informed the opposite counsel.
The request of respondent number 1 to 3. Release this matter of 2 weeks.
Much obliged, my lords.
page number 1 for orders regarding furnishing of PF, etc. Serial number, first time matter, serial number 1 to 8.
2 weeks.
Second time matter, serial number 9.
2 weeks.
Order non-compliance, serial number 10.
2 weeks.
Hearing interlocutory application matter, serial number 11 to 24.
Notice.
Application matter, serial number 25 to number 1.
Yes. Furnishing of process issue notice to R4. Weeks time is granted to do the needful. Yes.
Serial number 2, supervision for appellate.
My lord, serial, my lord, respond number 1 is ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ರಿಲಯನ್ಸ್ ಇವರು ತಗೊಂಡಿದ್ದಾರಂತೆ
ಯಾರು?
ರವಿ ಎಸ್ ಸಂಪ್ರತಿ ಫೋನ್ ಮಾಡಿದ್ರು.
Yes, Ravi S. Ramprati is directed to take notice for respondent number 1. Office is directed to show his name. Yes. Yes. Yes, this appeal may be called along with that so and so next week. Yes, next Thursday. Ready again. Yes, non-compliance of the office objection. Furnish appeal memo once at week's time is granted. Comply the top subject. Yes. Chandrasekhar B. furnishing PF issue notice. Acknowledgement not received. Week's time is granted to comply.
In this case, my lord, in this case, my lord, connected 5.1 filed by the apparent respondent number 2, my lord. Kindly direct Mr. Mohan to furnish copy, my lord.
Yes, Mr. Mohan. Number 5, Chandrasekhar. Yes, Mr.
Yes, my lord.
Where is Mohan Kian? Now that R2 is that represented by the appellant.
Appellant 5.1, my lord.
Yes, learned counsel for the appellant submits that Mohan K may be permitted to, may be directed to take notice for respondent number 2. Hence, Mohan K is directed to take notice for respondent number 2. Learned counsel for the appellant is directed to serve one set of copies.
ಇದು ರೆಕಾರ್ಡ್ ಬೇಕಾಗುತ್ತೆ ಸ್ವಾಮಿ, ಲಯಬಿಲಿಟಿ ಕ್ವಶನ್.
Office is directed to secure original. Non compliance officer. The process memo process memo, you have not paid that process. So Mahesh, furnishing a PF second time, week's time is granted to do the needful. Week's time is granted to do the needful. Sharif, week's time is granted to do the needful. For the appellant has filed a memo seeking dispensation of service of notice to R1. Memo is taken on record. Service of notice to R1 is dispensed. So PF issue notice. To issue notice, week's time is granted to complete the task. Yes, Mr. Issue notice to R6. R6 second time, postal server has left. R6 owner, R4, you are appearing, you are already, that's what that, you are already there on that record. Respondent number 4 is a Narayanamma. What is that relationship between the deceased and the other? Who are that other Ellas? Alala. How they are related? They are children. Children of the Narayanamma. No. Deceased wife. Narayanamma is the mother of the deceased. No, that 1 to 3, how related to Narayanamma? They are children. ನಾರಾಯಣಮ್ಮಗೆ ಹೆಂಗೆ ನಾರಾಯಣಮ್ಮನ ಮಕ್ಕಳು ಅವರು 1, 2, 3 ಅಲ್ಲ ಈಗ ನಾರಾಯಣಮ್ಮನಿಗೆ 1, 2, 3 ಏನ್ ಸಂಬಂಧ, ಹೆಂಗ್ ಸಂಬಂಧ? ನಾರಾಯಣಮ್ಮಗೆ ಮಕ್ಕಳಿಲ್ವಾ, ಗಂಡ್ ಮಕ್ಕಳಿಲ್ವಾ? ಬೇರೆ ಇಲ್ಲ. See, Gurudev Prasad learned counsel appearing for respondent number 1 and 1 to 3 has submitted that. Respondent 1 to 3 are the legal representatives of deceased Narayanamma. That is respondent number 4. Submission is taken on record. The respondent number 1 to 3 are the only a legal representative of respondent number 4. They have been treated as legal representative of respondent deceased respondent number 4. Learned counsel for the appellant is directed to amend the cast title. Yes, in what about that other respondent? Steps tagabe. Yes, week's time is granted to pay the process, issue notice to Eli Keshav Prashant. Week's time is granted to take steps to pay the process. You inform him, let him amend that cost.
My lord, I am for the appellant, my lord.
Yes, Mr.
Notice to R2 may be dispensed with. If other side is ready, I am ready. If it's a case of injury,
he is not there. Yes. Notice
then,
to
my lord,
R2.
you will ask me kindly call for records, my lord.
Office is directed to secure original record.
Next week,
yes.
Like dispensation for R2 may kindly be done notice because he's a driver of the corporation.
What about that? Have you deposited the amount?
Well, I have deposited, but I don't know how it has missed. I will file it in the counter, my lord.
Yes, learned counsel for the appellant appearing through VCS submits that notice to R2 may be dispensed. To that effect, she will file a memo in the registry.
Very well.
Submission of learned counsel for the appellant is taken on record. Notice to respondent number 2 is dispensed.
And I
she
call for the
takes
record.
weeks time to file an acknowledgement for having deposited that 50% of the award.
Very well. And call for the LCR also.
Office is directed to secure original records from the tribunal.
Very
R2 is dispensed. All along with that so and so. Records ಏನಾರು ಬೇಕಾ? ಬೇಡ. ಅವರು ಏನಾರು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ ನೆಗ್ಲಿಜೆನ್ಸ್. ಮತ್ತೆ ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಲ್ಲ. I have to see that in challenge. ಇಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೊಂದ್ಸರಿ ಬಂದಾಗ ಮತ್ತೆ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ಫರ್ ಮಾಡಿಬಿಟ್ಟು. See, now there is no matters for this thing. All matters either under the process or calling for the records. Hence, one for all, instead of that, I will call for records. Yes. All along with that so and so. The office is directed to secure original records. Second time, huh? Reliance General Insurance Company. Huh? Pradeep is directed to take notice for respondent number 2. Terminate counsel for the office. Yes, Srinivas. Patil Karegowda. What do you have? Week's time is granted to pay the process issue notice to respondent number 1.
My lord, serial number 17, my lord.
Yes.
Mr. Jalkumar seeks 1 week's time to pay the PF.
Yes.
And he will verify whether amount is deposited or not. In fact, it is deposited. He will get the information and fund.
Each time is granted to do the needful. Depositing of 50%. Yes, Mr. Have you deposited? Week's time is granted to learned counsel for the appellant. There's week's time to produce acknowledgement for having deposited the 50% of the award amount. Yes. Notice to R2. Who is that R2, Mr.? The owner may liability ಆಗಿದೆಯಾ? Yes. Week's time is granted to pay the process. Issue notice to respondent number 2. This matter along with it. Yes. Two weeks time is granted to take necessary steps in respect of deceased R4. Two weeks time is granted to do the needful. Waiting service of respondent number. Waiting service. United India ಯಾರಿದ್ದಾರೆ? Janardhan Reddy is directed to take notice for respondent number 1. Learned counsel for the appellant is directed to serve 1 set of copies. Filed in a memo seeking dispensation of notice to R2. Memo is taken on record. Notice to R2 is dispensed. week's time is granted to do the needful. The net counsel for the appellant has filed a memo. Dispensation of notice to R1. Dispensed. Yes, what is this matter? It can, if you are ready, Samati usually will come. Yes, release this matter of 2 weeks. So ready.
But I am for appellant, my lord.
Yes.
My lord, it's a case of injury. There is a short delay of 67 days.
Yes, dispense is to R1. Delay of 67 days is condoned. Ready?
Ready, my lord. My lord, may I submit, my lord?
Yes.
My lord, date of accident is 21/4/2016.
Yes.
My lord, a lady aged 35 years.
Yes.
Working as an agriculturist and coolie.
Yes.
My lord, sustained fracture of both the bones of right leg.
Yes.
Fracture of left tibia.
Yes.
And there is a other injuries also, my lord. That is
Yes.
all as lacerated and other injuries. He
Yes.
was initially treated at Janapriya Hospital for 7 days.
Yes.
Underwent a surgery.
Yes.
Surgery to both the legs, my lord.
Yes.
I have examined the doctor. Doctor evidence is important in this case, my lord.
Yes.
But according to Dr. Mellard, he assessed the disability of both the lower limbs by adopting the prescribed method and stated that right lower limb disability is 32% and left lower limb disability is 30%, but whole body disability not assessed, Mellard.
Where is that discussion of the doctor?
It is all found in page number 6, para number 11 onwards. And as far as the
matter is connected with MFA 3173 of 2017 by the appellant.
Oh Mahesh.
3173 of 2017.
Oh Mahesh, mute ಮಾಡ್ಕೊಳ್ಳಿ.
Yes.
Para number 13 is relevant.
Disability with respect to the right lower limb. And 30% disability with respect to the left lower limb.
So cumulatively it comes to 62%. One.
Yes.
So, about more than 20% she is suffered. 20% ತಗೊಳ್ಬಹುದು. Tribunal 15% ತಗೊಂಡಿದೆ.
Yes, yes.
ಇದರಲ್ಲಿ ಅವಳು ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ 8,000 ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾಳೆ. ಆದ್ರೆ ಚಾರ್ಟ್ ಪ್ರಕಾರ 9,500.
Yes. Yes.
No documentary evidence is forthcoming.
Yes. Then what is other
other heads, my lord, as far as pain and suffering is concerned? One by one, I will try to convince, my lord. Pain and suffering, my lord, the injury sustained is fracture of both the bones of right leg. Yes. And fracture of left tibia. About two surgeries she underwent and required 2 more surgery for removal of implants. Well, considering this aspect and in view of year of accident, 45,000, my lord, seems to be a lower side. It requires some marginal enhancement.
Yes.
And since she is a lady aged 35 years, a coolie, my lord, in view of these subsisting disability, loss of eminent is 25,000. ಇದರಲ್ಲಿ ಒಂದು ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡಬಹುದು, ಜಾಸ್ತಿ ಏನಿಲ್ಲ, ಸ್ವಲ್ಪ ಮಾಡಬಹುದು. ಆಮೇಲೆ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್ ಆಸ್ ಇಟ್ ಇಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸೊ ಇನ್ಸಿಡೆಂಟಲ್ 15,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗು 5 ತಿಂಗಳ ಕೊಟ್ಟಿದ್ದಾರೆ, ದಟ್ ಈಸ್ ಕರೆಕ್ಟ್. ಆದ್ರೆ 7,000 ತಗೊಂಡಿದ್ದಾರೆ. ಅದು ಸ್ವಲ್ಪ ಜಾಸ್ತಿ 5 ತಿಂಗಳ ಇದು. That is my difficulty is, my lord, as per chart 9,500, but in deposition itself she said her earning is 8,000.
8 into 5. 40,000 ಆಗುತ್ತೆ.
ಆಮೇಲೆ the major head is future loss. Melody as 15% attainable, it should be more than 20%.
Yes, we'll consider. Yes,
And there is no other contention. Future medical correct ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes. Shri Shastri, Cabinet Council appearing for the claimant has contended that at the time of the accident, claimant was earning 8,000 per month as an agriculture foodie. The tribunal has assessed the notional income of the claimant as 7,000 per month is on lower side. He further contended that due to that accident, the claimant has suffered grievous injury. She was inpatient for a period of 7 days. Doctor has been examined as CW1. In his evidence, he has assessed 32% disability in respect of right lower limb, 30% in respect of left lower limb. The tribunal has assessed whole body disabilities, 15% is on lower side. He further contended that due to that extent, the claimant has suffered grievous injury. She was inpatient for a period of 7 days. She has suffered a lot of pain during the treatment. She has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, the Ravi Learned Council appearing for insurance company has contended that even though the claimant has claimed that she was earning 8,000 per month, she has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 7,000 per month. He further contended that considering the evidence of doctor and considering that injury suffered by the claimant, the tribunal has rightly assessed the whole body disabilities is 15%. Last, he would further contended that considering that injury suffered by the claimant, considering that wound certificate exhibit P6 and evidence of Dr. Abdul Bashir, CW1, that tribunal has granted a just and reasonable compensation. Lastly, he has contended that interest awarded by the tribunal 8% is on higher side. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties. There was judgment and award. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 21/4/2016 due to rash and negligent driving of driver of tractor trailer bearing registration number KA13 P7745. Due to the accident, the claimant has suffered the following injury. She has examined Dr. Abdul Bashir as CW1. In his evidence, he has deposed that the claimant has suffered 32% disability with respect to right lower limb, 30% disability in respect of left lower limb. Considering that evidence of doctor and considering the wound certificate exhibit P6, I am of the opinion that the whole body disabilities has to be assessed 20%. The claimant has claimed that she was earning 8,000 per month as a coolie. Considering that evidence of PW1, I am of the opinion that the monthly income of the claimant has to consider as 8,000 per month. The multiplier applicable to the TH group 35 is 15. Accordingly, loss of future earning has been reassessed as follows. 8,000. 8,000. Due to the accident, The claimant has suffered grievous injury. She was inpatient for a period of 7 days. She has suffered a lot of pain during the treatment. She has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, considering that injury suffered by the claimant, I'm inclined to enhance the compensation for pain and suffering from 45 to 55,000. Loss of amenities from 25,000 to 40,000. Loss of income during the later period has to be granted for 5 months. The enhanced compensation amount carries 6% interest. Accordingly, the appeal is disposed of.
Future loss ಎಷ್ಟಾಗಿದೆ ಅಂತ ಸಾರಿ future loss
2,88,000. Memo filed for dispensation of notice to R1 is dispensed. Delay of 51 days in filing an appeal is controlled. Memo for dispensation is dispensed for R1. 159 days delays in condone subject to condition not entitled for the interest. Appeal is directed to secure original records from the tribunal. Yes. Yes, Mr. Mahesh. Delay of 84 days in filing an appeal is condoned. IA 1 of 2019 is allowed. Records is necessary, Mahesh.
Break for stay, my lord.
Serial number 30.
No, there was no coverage as on the date of the accident, my lord. We have produced the policy, but the tribunal has not referred to it, my lord.
Yes. Is there any execution has been filed?
Yes, my lord, it has been filed, my lord. I have told it has been filed.
Stay of judgment and award dated 14th September 2018, subject to condition passed by MECT Chitradurga and MEC 466 of 2017. Subject to condition deposit of 50% of the award amount with interest before the tribunal within 4 weeks from today.
Please.
Counsel for the appellant submits that this appeal may be called along with that. MFA CRAB. Yes. Yes. Memo for dispensation dispensed. Delay of 87 days in filing an appeal is condoned. IA 1 of 2019 is allowed or admit. Yes. Yes. On what? Yes, Mr. On what ground you are challenged? Huh? Ready? Both of them ready? Will dispose. Records bandidya. Records are there. Yes, when you are ready, Mr. Yes. Why that other appeal is filed by that? Is it connected? ಹಂಗಾಗಿ ಇಬ್ರು ಫೈಲ್ ಮಾಡಿ. Yes, you both has to be argument. Yes. Release this matter on Tuesday. Yes, Tuesday. Yes. General order before single judge. Yes, Prakash. Who is the Prakash? On what ground they are challenged, Mr. Riker? Yes, Prakash bandidya. Yes. ಒಂದು ಕೆಲಸ ಮಾಡಿ, You file a memo for withdrawing that amount. Then they will come. Otherwise, we'll permit it to withdraw. You have withdrawn that. Then he is not coming. Records will secure the records. Office is directed to secure original records from the tribunal. Post immediately after receipt of the record.
I appear for appellants, ma'am.
Yes. Reliance General Insurance Company. Internet Counsel for the appellant has filed a memo seeking dispensation of service of notice to R1. Memo is taken on record. Service of notice to R1 is dispensed. There is a delay of 2,146 days in filing an appeal. IA1 of 2019 is filed for condonation of delay. The respondent has served. Now, what about that CFC has made note that regarding the deceased Arthur payment of this? A respondent has served. None appear. No objection has been filed. For the reason stated in the accompanying affidavit, delay of 2,146 days in filing an appeal is condoned. IA1 of 2019 is allowed, subject to condition. Appellant is not entitled for the interest for a period of 2,146 days. Heard, admit.
The next is also connected, madam. It is connected, madam.
Yes. Sir, madam.
31 ನಲ್ಲಿ ಇನ್ನೊಂದು connected ಇದೆ. Serial number 31 ನಲ್ಲಿ it is connected with MFA 4061 of 19, madam.
31 connected with
4061 of 2019.
Yes.
Number 36 is based on the appellant.
Yes. Delay of dispensation of notice to R2 is dispensed. IA1 of 2019 is filed for condonation of delay. Delay of 261 days in filing an appeal. For the reason stated in that respondent is served unrepresented. No objection is filed. Delay of 261 days in filing an appeal is condoned. IA1 of 2019 is allowed. Subject to condition, appellant is not entitled for the interest for a period of 261 days. United India Insurance Company, you want to take notice. Janardhan Reddy is directed to take notice for respondent number 1. Yes. Yes. Manjula Tejaswini ಎಲ್ಲಿದ್ದಾರೆ ಮೇಡಮ್ ಬರ್ತಾರಲ್ಲ ಪಾಸ್ವರ್ಡ್ only case of death ಕೊಡಿ R2 dispensed. Delay of 54 days is condoned. Who is appearing, madam alla Raju is not filed an wakala. Yes, what is the case? Tara? What is the date of the accident? 18. Yes, what is the team? 19 years. Working as a sales promoter, earning 12,000. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್ ಅವರು? 8,000. 18. 12,000 you have claimed. You ಕೇಳಿದ್ದೆ 12,000. ಅಲ್ಲಲ್ಲ, you said that you are earning 12,000. ನೀವು ಕೇಳಿರೋದೇ 12,000. 12,500 ಕೊಡಕ್ ಹೆಂಗ್ ಬರ್ತದೆ ನೋಡಿ ಅಲ್ಲಿ. ಗೆಟಿಂಗ್ ಸ್ಯಾಲರಿ ಆಫ್ 12,000 ಕೇಳಿರೋದೇ ಅಷ್ಟು. ಎಸ್. ದೆನ್ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರಾ? 40% ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಷ್ಟು ಡಿಡಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ? 50. ಬ್ಯಾಚುಲರ್ ಅದೆಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ. ಏನು he died after some time, not on the same day. When he has died, Mr. ಅಲ್ರಿ ಅವತ್ತೇ ಸತ್ತೋದಂಗಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಹಾಸ್ಪಿಟಲ್ ಚಾರ್ಜ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಯಾವತ್ತು ಸತ್ತೋಗಿರೋದು. He was treated, when she was shifted to AG hospital, and she was shifted to hospital where she was sent course about on 150 postmortem. On 18/4 she has died. 18/4/2018. ಅದು ನೋಡ್ರಿ, ಅವ್ರದ್ದೇನಾರ ಅಪೀಲ್ ಇದೆಯಾ? ಸರ್ ಅಪೀಲ್ ಇದೆಯಾ ಚೆಕ್ ಮಾಡಕ್ಕೆ ಹೇಳಿ. One being a insurer, offending vehicle is directed to deposit the company within 2 months from the total compensation. Right. Council of at the time of the accident, deceased was working as a sales promoter at MS Bella Healthcare Private Limited and getting salary of rupees 12,000 per month. The tribunal has considered the notional income of the deceased as 8,000 is on lawyer side. He further contended that in view of judgment of apex court in case of Magma, the claimants are entitled 40,000 each. Hence, he sought for enhancement of compensation. For contra, Srimati Manjula N. Tejaswani, Bernard Council appearing for the insurance company, has contended that even though the claimant has claimed that deceased was earning 12,000 per month, they have not produced any document to establish the same. Therefore, the tribunal has rightly considered the notional income of the deceased as 8,000 per month. She further contended that considering the age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Hence, she sought of the appeal. Heard the learned counsel for the parties. There's judgment and award. It's not in dispute. What is the name of the deceased, Mr.? Yeah, no, deceased resident, right? Besides impact, deceased fell down on ಯಾವ್ದಾದ್ರು ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಇರ್ಬೇಕು ನೋಡ್ರಿ, ಇಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲಿ ಇರೋದಂಗ. Aji, you are appearing or Manjula Tejaswini is appearing? Huh? Huh? Sumalji. I think she has filed an wakalat. Yes. Yena Esra? It's okay. No problem in assisting the court. Yes. What is her name? Sumaji. No, your name is also there. You have been directed to take notice. Your name is also there. B.B. Raju wakalat not filed, but her name has been thrown aside. What is her name? Sumaji. Died in road traffic accident occurred on 13/4/2018 due to rash and negligent driving of driver of lorry bearing registration number KA01 AA5146. The claimant has claimed that Deceased was aged about 19 years and she was working as a sales promoter at Miss Bella Healthcare Private Limited and getting salary of rupees 12,000 per month. Even as per the chart, the notional income for 2018 is fixed as 12,500. Therefore, the monthly income of the deceased can be assessed as 12,000 per month. The tribunal has rightly added 40% of the income of the deceased for future prospects and deducted 50% of the income of the deceased since she was and considered 50% for a spinster. Considered multiplier as 18. Accordingly, loss of dependency has been reassessed as follows. Yes. In addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of Nagma, who are the claimants? Parents are? Yari avro? Father and mother. Yes. The claimants are entitled 40,000 each for filial consortium. The compensation awarded by the tribunal for medical expenses, conveyances, for loss, medical expenses and conveyances has been retained. Conveyances 10,000, medical expenses. Our medical expenses 1 lakh 2,143 and conveyances 10,000 plus remaining 6% interest. Yes. ಅಲ್ಲ ಮಂಜುನಾಥ್ ಯಾರಿಗೆ ಯಾರಿಗೆ ಹಾಕಿದ್ದಾರೆ ಓನರ್ಗೆ ಮತ್ತೆ ಕ್ಲೈಮೇಟ್ಸ್ ನೀವೇ ಅದಿ ಯಾರಿಗೆ ಓನರ್ಗೆ ವಿಲ್ ಗಿವನ್ yes clarification regarding the learned council for Sri Manjunath AB learned council page. Delay of 124 days in filing an appeal is condoned. IA 1 of 2020 is allowed. Records Beka, office is directed to secure original records from the tribunal.
I appear for appellate.
Ready? Yes.
Case of injury. She was
Yes.
aged about 47 years
Yes.
and doing tailoring work and earning a sum of rupees 20,000 per month. And accident is dated 31/12/2017.
Yes.
8,000 has taken.
Yeah.
And she was impatient for a period of 12 days.
Yes.
Fracture. You last period is kind of the spinal compression fracture, vertebra fracture.
Yes.
She has sustained 5 fractures.
Yes.
Income should have been taken at 20,000. And
Yes.
disability, doctor has assessed the disability
Yes.
to an extent of 20% to whole body, but 20% is taken. But
Yes.
nature of injuries sustained by the appellant,
Yes.
disability ought to have been taken more money.
Yes.
The disability is stated in para ink page 12.
Respondent, Mr. No, Ravi Samprati is which case? 4-0, you are not there, Mr. Yes. Yes, Mr. Ravi. Yes. 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 Loss of her. Yes. Yes. Interest is important. 6%. Shri Shantraj, Cabinet Council appearing for the claimant has contended that due to that extent, the claimant has suffered 2 grievous injury. He has examined. She examined the doctor. Doctor has assessed the disability, 20% permanent disability to whole body. The tribunal has assessed the whole body disability is 20% is on lower side. He further contended that at the time of the accident, the claimant was earning 20,000 by working as by doing a tailoring. The tribunal has assessed the notional income of the claimant as 8,000 per month is on lower side. He further contended that due to the extent, the claimant has suffered grievous injury. She was inpatient for a period of 12 days. She has suffered a lot of pain during the treatment. She has to suffer this disability and unhappiness throughout her life. The compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, she sought for enhancement of compensation. For contra, Shri Ravi Samprati, Learned Counsel appearing for insurance company has contended that the claimant has examined the doctor as PW2. In his evidence, he has deposed that she has suffered 20% permanent disability to the whole body. Considering that evidence of doctor, the tribunal has rightly assessed the whole body disabilities is 20%. He further contended that even though the claimant has claimed that she was earning 20,000 per month, she has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 8,000 per month. You would further contended that considering that evidence of doctor, considering that injury suffered by the claimant, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Peruse, judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 31st/12/2017 due to rash and negligent driving of a rider of motorcycle bearing registration number KA02 MJ 6805. Even though due to the accident, the claimant has suffered the following injury. She has examined the Dr. Prasad as PW2. In his evidence, he has deposed that the claimant has suffered 20% permanent disability to whole body. Considering the evidence of doctor and considering that wound certificate exhibit P5, the tribunal is justifying assessing whole body disabilities 20%. Even though the claimant has claimed that she was earning 20,000 per month at the time of the accident, but she has not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2017, the notional income has to be considered as 11,000. At the time of the accident, she was aged about
47 years.
47 years. The multiplier applicable to that age group is 13. Accordingly, loss of future earning has been reassessed as follows. Due to that extent, the claimant has suffered the aforesaid injury. She was inpatient for a period of 12 days. She has suffered a lot of pain during the treatment. She has to suffer this disability and unhappiness throughout her life. Considering that evidence of doctor, considering that injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 30,000 to 50,000. Loss of immunities from 30,000 to 40,000. Loss of income during the later period for 3 months. The compensation awarded in the other hand are just and reasonable. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as well.
Keshava Prashant.
Vishwanath K. For dispensation is filed, dispensed for R1. Delay of 240 days in filing an appeal is condoned. IA 1 of 2020 is allowed subject to condition. Appellant is not entitled for the interest for a period of 240 days. Learned counsel for the appellant submits that we will not press for memo for dispensation. Hence, dismissed as not pressed. Issue notice to respondent number 1. Manager, National Insurance Company, who is there further? Patil is directed to take note. Respondent number 2 served unrepresented. Patil is directed to take notice for respondent number 2. Learned counsel for the appellant is directed to serve one set of cards. Memo for dispense. You want to dispense for R1? Yes, memo is filed. Dispensation of notice to R1 is dispensed. this was noticed. Ravi S. Samprati is directed. Up to Ravi S. Samprati is directed to take notice for respondent number 2. Bernard counsel for the appellant is directed to serve one set of copies. Yes. ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಎಸ್ ಸರ್ವೆ ಕಾಪ್. Yes, Mr. What is this? Being satisfied with the part shown. Bernard counsel of director serve a set of copies. Yes, Mr. Vijay Kumar, what is this?
Serial number 44, P. Vijay Kumar for petitioner.
My lord, this even for respondent number 1 also, Mr. Gopalakrishnan is appearing for this. My lord, this matter was decided ex parte without my presence,
Yes.
my lord. Even I have not filed wakalat and also not knowing that matter was posted. My lord, formally the review petition may be allowed and judgment may be restored, and next week only it can be disposed of.
No, what is that error in that judgment?
My lord,
Now, is there any required for any clarification in the judgment, Mr.
yes, my lord, yes, my lord.
What is that? What is that error?
Just a minute, lord.
This is for amendment.
My lord, kindly pass over, my lord.
Yes. Why on that day he was not there?
I was not there, my lord. Even I was not knowing that matter was posted on that day. Maybe RP may be allowed and may be restored, and next week it may be disposed of.
No, that your appeal, how can I decide without in your
ಅಲ್ಲ
presence?
ಇದರಲ್ಲಿ earlier ಏನಾಗಿದೆ ಅಂದ್ರೆ in the other appeal my lord, one minute. Corrected appeal ಅಲ್ಲಿ just I'll make one submission, maybe pass over, my lord. I kindly pass over.
Pass over. Yes, pass over. Let us see what is there.
ಅಲ್ಲ ಇದರಲ್ಲಿ 1 minute,
Let us see,
one
Mr.
submission.
Why?
My lord, I have produced the judgment of the court in the current. Anyway, I'll make submission in the this, my lord. Kindly pass over. Kindly pass over.
Let us. Yes. P. Suresh. Yes. Where is that? None appear. Or admit. Oh, yes, you are respondent. You will admit it. He is not there. There. Or admit. Yes, Sridhar. Where is that Sridhar? Yes, Mr. Sridhar. Idra, pass over. Oh, what is this, Mr.? Huh? What is the finding of the tribunal?
In one stretch. One stretch you are place for 14 days. Is undergone any surgery?
Okay.
What is the disability?
Volume ತೆಗೆದಿ 14 ಮತ್ತೆ 2014 Where is that discussion? Nexus between the injuries show that best price of evidence come on so and so. As per the result, deceased fell down from the tempo. Because of his own negligence, he has sustained injuries since he was gratuitous passenger. Company is not liable to pay the compensation. I'm going to the deceased was traveling in the said tempo as a coolie worker. He fell down when he was driver suddenly reversed vehicle. As per the complaint, at around 2014, volume 14. He fell down when the driver suddenly reversed the vehicle. As per the complaint, accident occurred on 18/9/2007. The respondent has failed to produce any contra document which speaks otherwise. No grounds is disbelieved. So on. Yes, we have taken, but we have not proved that he was a gratuitous passenger. Then what evidence? That is what that even Supreme Court also said. It should be proved. Case of death, ಅವ್ರದ್ದೇನು ಕ್ರಾಸ್ ಅಪೀಲ್ ಇಲ್ಲ, ಎನೌನ್ಸ್ಮೆಂಟ್ ಇದೆ. ಯಾರ್ಯಾರು ಎವಿಡೆನ್ಸ್ ಯಾರ್ಯಾರ್ದು ಇದೆ? Who is PW2, Mr. Ramesh? Who is Ramesh? PM, husband of Sri Balachandra, along with one Ramesh, who is the close friends of my husband, were started to go on to coolie work. At that point of time, one tempo bearing registration numbers came to the Kasoli village to take my husband and Ramesh to coolie work. At that time, the driver of the tempo driver husband was sister to phone. My husband was Helen Delhi before accident coolie was Who is other side, Mr. Srinivas Rangaswamy Yaro? ವಿಷಯ ನನ್ನ ಅಣ್ಣ ರಮೇಶ್ ನನಗೆ ಹೇಳಿರ್ತಾನೆ. ಅಪಘಾತ ಅವರಿಗೆ ನನಗೆ ಹೇಳಿರ್ತಾರೆ. ರೀತಿ ಬಗ್ಗೆ ಹೇಳಿರ್ತಾರೆ. ಗಂಡ climate So their case is that when you are due to the accident, VL Nagana fell down on drainage. Immediately myself others taken to the CH-16. Yes, where is Pradeep? Pass on. Yes, Manjunath. Where is Manjunath? Why that advocates are not coming? He is not there. What to do? We'll issue rule. Yes. Issue rule. So we admit. Yes,
Case of Lord's damage.
yes.
It's already a claim made by one of his own insurer. The court has awarded not like 75,000.
Yes.
And I have a challenge. Tata is
Yes.
But I requested Lord's information with regard to what is the amount they have paid. So it's not.
Yes. Yes, Mr. You are appearing for owner. You have already claimed that damages from what do you claim? Why you are entitled? In which law you are entitled for twice? If you are already received by what do you claim? Let us see if he is agreed. Yes, you have to say how much you have paid. ಕೇಳ್ಬೇಕ್ರಿ ಅಷ್ಟೇ ನೀವು ದುಡ್ಡು ಕೊಟ್ಟಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಿಮ್ ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ ಕೊಟ್ಟರೆ ಮುಗ್ದೋಯ್ತಪ್ಪ ಕೇಸ್. Yes. No, they will not reply their own unless you put in a pressure. Otherwise, these are all simple matters. This pending. Two matters can be disposed of.
Because what they have produced is 65 crores is an estimate. But that also not work out only not 1,2,555. That also is not in the name of Tata Insurance here. And not there is no other notes document.
On what basis tribunal has granted 3 lakhs? What is that vehicle?
Tata
Innova. ತರ್ಮಸಿ 1 ಲಕ್ಷ ಪರಿಹಾರ ಕೊಡುವಂತ ಆದೇಶಿಸಿಕೊಂಡು ಹೇಳಿರ್ತಾರೆ. ಅಲ್ಲ, ಅಪಘಾತದಿಂದ ಅರ್ಜಿದಾರರಿಗೆ ಉಂಟಾದ ಮಾನಸಿಕ ನೋವು ಮತ್ತು ಯುವಕನಿಗೆ
notes is granted, but on the basis of assumption that ಅರ್ಜಿದಾರರು ವಾಹನದ ರಿಪೇರಿಗೆ ಅಂದಾಜು ರೂಪಾಯಿ 3,50,000 notes in 21.
Yes.
Notes because of the injuries notes as reflected in the IMD report. That is the notes reasoning of the tribunal.
ಅಲ್ಲ ಇಂಜುರಿಗೆ ಬೇರೆ ಡ್ಯಾಮೇಜ್ಗೆ ಬೇರೆ ಅಲ್ಲ. ಯುವರ್ ಅಪೀಲ್ ಇಸ್ ಅಗೇನ್ಸ್ಟ್ ದಟ್ ಇಂಜುರಿ ಆರ್ ಡ್ಯಾಮೇಜ್. ಮತ್ತೆ ಇಂಜುರಿ ಅಂತ ತೋರಿಸ್ಬಿಟ್ಟಿದ್ದಲ್ಲ ನಿಮ್ದು ಅನೌನ್ಸ್ಮೆಂಟ್ ಡ್ಯಾಮೇಜಸ್ ಇದೆ. ಇಂಜುರಿಗ ಡ್ಯಾಮೇಜ್ಗ ಇಂಜುರಿಗೇನೋ ಕ್ಲೈಮ್ ಇಲ್ವಾ? ಇಂಜುರಿ ಒಂದೇ ಡ್ಯಾಮೇಜಸ್. ಮತ್ತೆ ಇಲ್ಲೇನು ಮತ್ತೆ ಏನೋ ಅಲ್ಲ. ಪ್ಯಾರಾ 17 ನೋಡಿ. ಅಪಘಾತ ಅರ್ಜಿದಾರರಿಗೆ ಉಂಟಾದ ಮಾನಸಿಕ ನೋವು ಮತ್ತು ಯುವತಿನ ಅನುಭವಕ್ಕೆ 1 ಲಕ್ಷ ರೂಪಾಯಿ ಪರಿಹಾರ ಕೊಡುವಂತೆ ಆದೇಶಿಸ್ತಾರೆ. ಮಾನಸಿಕ 20,000 ಕೊಟ್ಟಿದ್ದಾರಾ? ಇರ್ತಾರೆ. ಮತ್ತಿನ್ನೇನು ಕೊಟ್ಟಿದ್ದಾರೆ? ಕಾರಿಗೆ 4 ಲಕ್ಷ ಕೇಳಿದ್ದಾರೆ. ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ ರೀ 4 lakhsಗೆ?
And now there is another document. Insured owner, actual claim of your vehicle's number. You have deputed an IRDA licensed surveyor.
Has the surveyor has been examined? Then let us see what is that information you will get. Yes, you next week, Mr. Patil. At the request of parties, release this matter next Friday. Next.
I pay for the fifth respondent.
Yes. Yes, madam. Yes.
The logic in this case,
Yes.
doctor has assessed the permanent disability of 20.7% the right lower lip and 15.33 the right lower lip.
Yes.
So by looking at the profession, it was a cook.
Yes.
And the overall disability taken is only 12% a lot.
Where is the discussion of the doctor?
Page number 14 of ABC judgment.
Yes.
Para 20.
Yes.
Has stated that the petitioner has a permanent physical impairment of 23.7% the right lip and 15.33 right lower lip. So it's disability certificate issued by PW also releases the same. Hence, considering the evidence of the medical officer and the disability certificate, I'm of the considered view that petitioner has suffered the disability of 12% disability to the whole body.
Yes.
Lordship, I would like to place a judgment.
12% disability ತಗೊಂಡಿದ್ದಾರೆ. Yes.
Lordship, Ponnavam versus Reliance General Insurance Company Limited and others. Next page, Lordship, para 4 it has been stated.
Yes.
At the outset, it is required to be noted that looking to the injury sustained by the claimant and the permanent partial disability assessed by the Regional Medical Board, the learned tribunal considered the functional disability at 90% and awarded the compensation for the loss of earning capacity accordingly. However, in an appeal by the insurance company, the High Court has reduced the functional disability from 90% to 30%. Accordingly, has reduced the amount of compensation under the head of loss of earning capacity. Considering the fact that the claimant was working as a movie and the injury sustained by God, namely the fracture of the left leg, right hand crash injury, and multiple injuries all over the body, considering the medical report of the Regional Medical Board, the High Court has committed a great error in reducing the functional disability from 90% to 30%. Therefore, we restore the judgment and the order passed by the learned tribunal so far has awarded the future economic loss considering the functional disability at 90%.
Yes. How it is applicable to your case?
Even though we haven't stated separately what physical as well as functional disability is, but by looking at his profession, as he's a cook and his right leg is being damaged also. With that, you can at least consider it as 30 years also. If you get a total of 23.7 plus 15 comes up to 40 years also. 39 point something comes. Whereas
40% ಆದರೂ 13% ಬರ್ತದೆ.
13% ಬರುತ್ತೆ. Yes. Doctor, he has taken 12.
ಹೌದು. Tribunal has taken it as 12.
Yes.
That is too very less here also.
Yes.
Because you won't be able to work again.
Yes. Yes. What is that income you have assessed? What is
The
the
absence
income?
of evidence, 12,000.
Just 12,000.
How much you have claimed?
I have claimed 30,000 euros.
No evidence, no documents.
As a cook?
Yes, Your Lordship.
Tribunal has taken
12,000.
12,000.
2017 extent, huh?
Okay.
Yeah. Yes. Yes. What is his age? 55 years.
55 years, Your Lordship.
How many days you are in the hospital?
For almost 4 months, 20 days I was in the hospital. That is
31/10/2017 to 20/11/2017.
Yes. How many days tribunal has calculated?
Same, Your Lordship. 4 months.
20 days.
20 days. 4 months, 20 days.
No, petitioner was hospitalized for 20 days. 4 months.
Aste.
Where is
20 days.
Yes. Yes. Pain and agony has granted 1 lakh.
Also
Loss of immunities,
50,000.
nourishment, medical expenses, loss of income during the later period, conveyances. No, he has granted exorbitant. There is no scope.
Howdu.
Even what is that? He has even that pain and suffering and all he has granted. I thought that other head
1 lakh ಕೊಟ್ಟಿದ್ದಾರೆ.
8% interest. Yes, that's all.
Only the disciplinary percentage can be recalculated.
Yes. Yes. So and so learned counsel appearing for the claimant has contended that at the time of the accident, the claimant was working as a cook. Due to that accident, he has suffered a grievous injury. He has examined the doctor as PW2. In his evidence, he has deposed that the claimant has suffered permanent physical impairment of 23.7% to right limb and 15.33% to right lower limb. The tribunal has assessed whole body disabilities 12% is on lower side. She further contended that at the time of the accident, he was earning 30,000 per month as a cook. The tribunal has assessed the notional income of the claimant as 12,000 is on lower side. Lastly, she has contended that due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of 20 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, Sri Punacha Learned Counsel appearing for insurance company has contended that even though the claimant has claimed that he was earning 30,000 per month, he has not produced any document to establish the same. Therefore, the notional income assessed by the tribunal, 12,000 is just and reasonable. He further contended that considering that evidence of doctor, considering that injury suffered by the claimant, the disability assessed by the tribunal is just and reasonable. The compensation awarded by the tribunal for pain and suffering, loss of immunities and other incidental expenses is on higher side. And also, the interest awarded by the tribunal 8% is on higher side. Heard the learned counsel for the parties. Arose judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 31/10/2017 due to rash and negligent driving of driver of car bearing registration number MH09DM4803. Due to that accident, the claimant has suffered the following injury. He has examined the doctor Umesh Prabhu as PW2. In his evidence, he has deposed that the claimant has suffered 23.7% disability to right limb and 15.13% to right lower limb. He he has not assessed whole body disability. Considering that evidence of doctor, considering that injury suffered by the claimant, I am of the opinion that the whole body disabilities can be assessed 14%. Considering that even though the claimant has claimed that he was earning 30,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 12,000 per month. The multiplier applicable to the age group 55 is 11. Accordingly, loss of future earning has been reassessed as follows. 12%. Due to that extent, the claimant has suffered the aforesaid injury. He was inpatient for a period of 40 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, considering that injury suffered by the claimant, I am inclined to enhance the compensation for loss of immunities from 50,000 to 60,000. For rest, nourishment and attendance charges from 30,000 to 35,000. Since they have filed an appeal, I have enhanced 5,000 rupees.
Correct. Illadadre assessment correct agittadu.
Yes, it is correct. Yes. Rest, nourishment, attendance charges 30 to 35,000. All other the enhanced compensation carries 6% interest. Other head just and reasonable. Yes.
Nice.
Yeah. Yes, Nagaraj K. Here for additional documents. Or admit. ಮಾಡಿಲ್ಲ ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ ಈಗ ಎಲ್ಲಿ ವೇರಿ 1 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರಾ Doctor has not been examined. Yes. ಏನು injury ಏನೋ How much you can additional? Where is Raju? ಏನು ಹೇಳಿದ್ರು? Have you spoken to him? Hello, he is agreed. Both has agreed for 30,000. Pass out. You get the both are agreed. Then we. Yes. Yes. Put it. Yes. 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 ಡಾಕ್ಟರ್ ಏನ್ ಹೇಳಿದ್ದಾರೆ? ಎಲ್ಲಿ ವೇರ್ ಇಸ್ ದ ಡಿಸ್ಟೆನ್ಸ್? Dr. Naveen, chest on right side has short joint, shortening of 8 centimeter humeral components and knee 60. He has assessed that permanent disability of right lower limb is 79%. Fitness has been transacted with the the disability, the doctor is on a higher side and that prisoner is suffering physical disability. But the suggestion has been denied. Nature of injury and tribunal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 25% ತಗೊಂಡಿದ್ದಾರೆ. 25 ಮೂರ್ಲಿ 75 ಸ್ವಲ್ಪ ಜಾಸ್ತಿ. 79 ಟೈಮ್ ಅಮೌಂಟ್ 9000. 2016 ಗೆ ಎಷ್ಟಿದೆ? ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? Why? Very yes said. Yes. Allah, then loss of future earning you are not entitled. Aitha. No, has he removed from his service? Who has asked to left, mister? No, mister. If you lose your finger, you can also resign. Then you can ask that entire life term 100% disability has to be given. Who asked to resign, mister? No. See, even then, is it an evidence to show that your employee has been refused to take into the service? If he is ready to take in service, why you have to resign, mister? Alre. No, that's what that on that reason employer has to say, no, you don't come to that work. Is it evidence that he has not allowed you to work or he has not taken into the duty? You yourself has freely, then tribunal has granted that loss of future earning. That is, you are not entitled then. If he has not proved. No, you cannot assume everything, mister. When you are working, you have to prove that you have been removed from the service, is it not? So you can say, even if you have lost your finger, you can say that I can't work, therefore I am resigned. That is limb, not whole body. Then, if it is 60 to 80% for whole body, then we can consider. Is it not? As is there any amputation? There is no amputation. Injury is Allah, it is not a permanent. It will be cured. But anyhow that, therefore you are taking 1/3. Amputation Allah idra iga, amputation of your leg, it cannot be cured at all. Injury gradually it will be improved in your this thing. Fractures reunited agate illa ಸ್ವಲ್ಪ ಏನಾರ problem agate. Therefore, for that you are assessing the disability. But it is not your case that you have been removed from the service. Yes, we will consider. Yes. That will consider. How many days you are in the hospital?
7 days.
7 days. 50,000? I was putting that. Yes. Interest? 6%. That's all. Well, yes, we'll consider your Sri Girimalaya, Karnataka Council appearing for the claimant has contended that due to that extent, the claimant has suffered grievous injury. At the time of the accident, he was working as an operator in Chamundeshwari Sugar Limited, ESP operator at Chamundeshwari Sugar Limited, KM30. He has examined the doctor, Naveen as PW2. He has assessed that there is a permanent disability of right lower limb at 79%. Due to that disability, he was unable to do his day-to-day work and he has resigned from his service. The tribunal has not assessed functional disability. The whole body disability is assessed by the tribunal. 25% is on lower side. He further contended that at the time of the accident, he was earning 9,000 per month. The tribunal has assessed the notional income of the claimant as 8,000 is on lower side. Lastly, he has contended that due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of 7 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. The tribunal has failed to grant any compensation for loss of earning during the later period. Hence, he sought for enhancement of compensation. Per contra, Sri Rishabhendra, Learned Counsel appearing for insurance company has contended that even though the claimant has claimed that he was earning 9,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 8,000 per month. He further contended that the claimant has examined the doctor as PW2. In his evidence, he has assessed the claimant has suffered right lower limb disability at 79%. Considering that same, the tribunal has rightly assessed whole body disability is 25%. The claimant has failed to prove that he has been removed from the service. He himself has resigned. Therefore, the tribunal has rightly not assessed any functional disability. Lastly, he has contended that considering that evidence of doctor, considering that injury suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the Learned Counsel for the parties. There was judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 9/8/2016 due to rash and negligent driving of driver of Tata Ace bearing registration number KA550986. Due to that accident, the claimant has suffered inpatient for a period of 7 days. He has examined Dr. Naveen as PW2. In his evidence, he has deposed that the claimant has suffered permanent disability of right lower limb at 79%. Considering that evidence of doctor, considering that injury suffered by the claimant, I am of the opinion that the whole body disabilities can be assessed 28%. Since the claimant has failed to establish that he has been removed from the service and he was unable to continue in his work, the tribunal has not considered for functional disability. Considering that he was working as an ESP operator at Chamundeshwari Sugars Limited, KM30, Bharati Nagar, and getting salary of 9,000 per month, the monthly income of the claimant can be assessed as 9,000 per month. He was aged about 33 years. The multiplier applicable to the age group is 16. Accordingly, loss of future earning has been reassessed as follows. Due to that extent, the claimant has suffered the following injury. He was inpatient for a period of 7 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, considering that injury suffered by the claimant, I am inclined to enhance the compensation for loss of immunities from 20,000 to 40,000. Loss of income during the later period is entitled for 3 months. The compensation awarded by the tribunal in the other hand are just and reasonable. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified.
My lord, I am for appellant, my lord.
Lordship, serial number 54.
It's adjourned, madam. It's adjourned.
PCR may be called, your lordship.
Yes. Yes,
My lord, I am for appellant, my lord.
Yes.
My lord, if doctor evidence is available in the court file, my lord, it may be disposed of, my lord.
Yes, yes. No, records is not there.
Oh.
The records required.
Andre disability 33%. Illa correct. Illa ಈ ಕೇಸಲ್ಲಿ ಬೇಕಾಗೋದಿಲ್ಲ sir. May I proceed, my lord?
Yes, yes.
My lord, extent is of the year 2018, my lord.
Yes.
A lady named Shobha, aged 37 years.
Yes.
Claims to be working as agriculturist as well as milk vending.
Yes.
For this, she claims to be earning about 20,000 rupees.
Yes.
To prove the occupation, my lord, some documents, that is a record of rights and a certificate issued by milk society is also produced.
Yes.
Anyway, there is no other authenticated documents to prove her income.
Yes.
She was sustained fracture of right biomellular.
Yes.
And fracture of tibia and fibula.
Yes.
And fracture of ankle. So
Yes.
there is 2, 3, 4 fractures.
Yes.
After taking first aid treatment in Arkalgudu Government Hospital,
yes.
She shifted to Manasa Hospital and underwent surgery. Total
Yes.
6 days inpatient.
Yes.
Medical bills 71,158. That has been accepted. 71,150.
Yes.
First contention is, as usual, these future laws. 5,000 is considered. Extent is of the year 2018, madam.
Yes.
As far as disability is concerned, I am not disputing. 11% is considered to whole body. I am not disputing on that point. 12,500 is to be considered.
Yes.
And appropriate multiplier is 15. It is adopted by the tribunal.
Yes.
That is the first ground.
Yes.
And pain and suffering for these 4 fractures, only 30,000 is awarded. Right, requires enhancement.
Yes.
As well as the amenities also, Malay, only 10,000 awarded.
Amenities.
10,000.
Yes.
Medical and incidental, Malay, I am not disputing.
Yes.
Loss of earning, only 5,000 is considered. 5,000 is awarded considering a loss of period as 1 month.
Yes.
At least this type of fractures, since she is a lady and milk vending and agriculture coolie.
Yes.
At least 3 to 4 months
Yes.
at the rate of 12,500.
Yes.
It is all the heads, Malay.
Yes. What is that interest awarded? 9%.
Interest. Sorry, Malay, I am not seeing that.
Yes, Mr. Sannath, that's all. Right. She
9% ಕೊಟ್ಟಿದ್ದಾರೆ 6% ಮಾಡಿಸು 9%.
She Sanmati, she is Shastri, learned counsel appearing for the claimant has contended that at the time of the accident, the claimant was earning 20,000 per month. The tribunal has assessed notional income of the claimant as 6,000 per month is on lower side, while 5,000 per month is on lower side. He further contended that due to the accident, the claimant has suffered grievous injury. She was inpatient for a period of 6 days. She has suffered a lot of pain during the treatment. She has to suffer this disability and unhappiness throughout her life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. Per contra, Sri Sanmati learned counsel appearing for insurance company has contended that even though the claimant has claimed that she was earning 20,000 per month, except producing some properties record, no other document has been produced to prove that she was earning 20,000 per month. Therefore, the tribunal has rightly assessed the notional income of the claimant as 5,000 per month. He further contended that the injuries suffered by the claimants are minor in nature. She was inpatient for a period of 6 days. Considering that evidence of doctor, considering that injury suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Lastly, he has contended that the interest awarded by the tribunal 9% is on lower side. Hence, he sought for 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Arose judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 26/8/2018 due to rash and negligent driving of rider of bike bearing registration number KA13 EF 9628. Even though the claimant has claimed that she was earning 20,000 per month and she has produced some property records, but no documents has been produced to show that she is getting 20,000 per month. Therefore, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2018, the notional income has to be considered as 12,500. The tribunal has rightly assessed whole body disabilities 11%. The multiplier applicable to the age group
15.
What is her age?
37.
37 is 15. Accordingly, loss of future earning has been reassessed as follows. Due to that extent, the claimant has suffered grievous injury. He was inpatient for a period of 6 days. She has suffered a lot of pain during the treatment. She has to suffer the disability and unhappiness throughout his life. Considering that evidence of doctor, considering that injury suffered by the claimant, I am inclined to enhance the compensation for loss of immunities from 10,000 to 30,000, pain and suffering from 30,000 to 50,000, loss of income during the later period for 3 months. The enhanced compensation amount carries 6% interest. Office is directed to delete the name of Ravish Ganni for R2 and show the name of EI Sanmati for respondent. Yes, Mr. Yes, ready. Both of them. Yes. Yes. You are traveling in a tractor. Wait. Let him. So you was traveling in a tractor was what? Mudgatala. Yes. Where is that evidence? Complaint put. Trailer was attached to the tractor. Tractor with the trailer and subsequently it was released in the rightly submitted to the non-possible petitioner as ordinarily for that people will call the tractor and trailer as a tractor and not a trailer traveling with trailer. ಏನಕ್ಕೆ ಟ್ರಾಕ್ಟರ್ ಟ್ರೈಲರ್ ಎಲ್ಲಿಗೆ ಹೋಗ್ತಿತ್ತಪ್ಪ? ಆಯ್ತು, ಎಲ್ಲಿಗೆ ಟ್ರಾಕ್ಟರ್ ಟ್ರೈಲರ್ ಎಲ್ಲಿ? ಕೂಲಿ ವರ್ಕ್ ಆಗಿ ಟ್ರಾಕ್ಟರ್ ತಗೊಂಡು ಎಲ್ಲಿಗೆ ಹೋಗ್ತಾ ಇದ್ರು? They are using the tractor for what purpose? ಅಲ್ರಿ, ಟ್ರಾಕ್ಟರ್ ಅವತ್ತು ನಿಮ್ಮನ್ನ ಕರ್ಕೊಂಡು ಎಲ್ಲಿಗೆ ಹೋಗ್ತಾ ಇದ್ರು? ಏನು ಅವೆಲ್ಲ ಬೇಕು? ಟ್ರಾಕ್ಟರ್ ಕೆನಾಟ್ ಬಿ ಯೂಸ್ಡ್ ಫಾರ್ ಅದರ್ ದನ್ ದಟ್ ಅಗ್ರಿಕಲ್ಚರ್ ಪರ್ಪಸ್. ಟ್ರಾಕ್ಟರ್ ಟ್ರೈಲರ್ ಇದ್ರು ಕೂಡ, ದಟ್ ಇಸ್ ವಾಟ್ ದಟ್ ನೌ ಯು ಹ್ಯಾವ್ ಹೆಲ್ಡ್ ಇನ್ ಫುಲ್ ಬೆಂಚ್. First you have to prove you are in a coolie and that tractor is used for agriculture purpose. Then only other contentions. Who is appearing for the owner? Where is Vijay Kumar? Who is Vijay Kumar? Then ultimately, if it is proved that either insurance company or the owner, no, you are entitled, but whether the owner, the last.
Vijay Kumar, which Vijay Kumar, Milord?
No, you are not Vijay Kumar K. Yes. No, Vijay Kumar R. He is for owner of the vehicle. You are owner of the KSRTC and APST. You are not owner of any other. Yes, he is. No, he is representing. then he cannot be a owner of private vehicle. Where is that complaint? ಏನಂದ್ರೆ ನಾನು ಕೂಲಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ಜೀವನ ಮಾಡುತ್ತಿದ್ದೇನೆ. ನನ್ನ ಮಗನಾದ 20 ವರ್ಷ ಶ್ರೀನಿವಾಸ ಸಮಯದಲ್ಲಿ ಶ್ರೀನಿವಾಸನು ಸಮಯದಲ್ಲಿ ಶ್ರೀನಿವಾಸ ಬೆಳಗ್ಗೆ ಯಾರೋ ನನಗೆ ಫೋನ್ ಮಾಡಿ ನಿನ್ನೆ ಮಗನಿಗೆ what about that Lokesh? ಅವ್ರ ಲೊಕೇಶನ್ ಕೇಸ್ ಹಾಕಿಲ್ವಾ? ಮೂಲ ವಿರುದ್ಧವಾಗಿದೆ. Has they examined that owner? ಪ್ರಕ್ರಿಯೆ ಮೇರೆಗೆ ಜಿಲ್ಲೆ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆ ಸಭಾಗಾರ Does that owner has filed a return statement? Time not maintained by the law as per government rules by petition. Owner yasna respondent claim idralli first respondent Basuraj. Yes. Appellant test so I also said that I facing a particularly the claim petition and the application for all members denied of all the petitioner even owner has denied that he were a loader and unloader. He has filed an objection. He has denied. Driver in rash and negligent manner. Said that this is the Srinivas doing in a labor work and earning 50,000 per month. Further cost to pay that. Right? No, even if you prove that you are traveling, owner has not said anything about that he is using his vehicle on that day for agriculture purpose. Otherwise, owner has to pay. Where is he? He has to explain. You see that latest judgments and all. Earlier, if your tractor and trailer is together, it can be treated as in a goods vehicle. That all that has gone. If he is traveling in the trailer as a employee loader, then vehicle has been used for an agriculture purpose, then you have saved. Otherwise, you are not, Mr. Now that full bench said, earlier it was not, earlier while traveling in that tractor and trailer, you can say that yes, you are an employee. Tractor and trailer cannot be used other than that agriculture purpose. That is what that full bench held. You see that? Yes, heard. No, Mr. Counsel, you have to prima facie satisfy the court. I have seen that evidence of the owner has filed an objection saying that you are not his employee. He is not said that my vehicle has not been used on that day. Yes, heard, admit. Yes, you have made out a case, we'll hear, post it for hearing, yes. Yes, it will come. Yes. Yes. But what is this? Which insurance company? United India ಯಾರು ಇದ್ದಾರೆ? Shivanagoda is there. Shivanagoda is directed to take notice for respondent number 2. Learned counsel for the appellant is directed to serve one set of copies on. This is Shivanagoda. Yes. Yes, Mr. What is this? Office is directed to TCR kept below. If you give the copy, we'll have it next week. Yes.
Yes. Krishna Swami.
Yes. Yes, ready. Yes, where is Krishna Swami? Yes, what is that? What is that in the death case? Is there any dispute? Yes. Where is he? Pastor. You get that judgment on that this thing. Even housewife. Ready? How much awarded? What is the disability?
6 years old.
No, what is that income taken by the prisoner? 8,000, 2018, 1,500. Pain and suffering ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಇದ್ರು? ಪೀರಿಯಡ್. Yes. Yes, Mr. Shantraj.
Which case 62. Is it?
Yes.
61 no?
62 ಅಲ್ಲ ಎಷ್ಟರದ್ದು? 62. Yes.
61 no?
61 you are not there, Mr. 62.
No, 61 also.
61 is urgent.
She has taken
61
time.
is urgent. 60.
She is
Yes,
playing
62.
unfair practice. She has not informed me.
Yes.
She is taking time.
Yes.
I want to withdraw the money. It's a case of death.
Yes.
ಏನು ತಾವು
ಯಾವತ್ತು ಹೋಗಿದ್ದಾರೆ?
ಸುಮ್ಮನೆ ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ರೆ ಅದು ಏನು ಅರ್ಥ ಇಲ್ಲ. ಅವ್ರು ಕೇಳ್ತಾರೆ.
No, if you want, you object it as 10:30.
No, I can't.
Yes.
I have to attend other courts. I can't. Appellants ಇದ್ದಾಗ ರೆಸ್ಪಾಂಡೆಂಟ್ ಟೈಮ್ ಕೇಳಿದಾಗ ಸ್ವಲ್ಪ ಇದನ್ನ ಮಾಡ್ಕೊಂಡು ಮಾಡ್ಬೇಕು. ಅದು ಆಕ್ಸಿಡೆಂಟ್ ಇದಾಗ ಅವ್ನು ದೇ ಆರ್ ನಾಟ್ ಗೆಟಿಂಗ್ ಎನಿ ಕಾಂಪನ್ಸೇಷನ್ ಸೋ ಫಾರ್. ಇದರಲ್ಲಿ 18 ಆಕ್ಸಿಡೆಂಟ್.
He wants you to commence first.
33% whole body disability. Fracture of L1 vertebra.
Disease was hired as a
and head injury, subdural hematoma, hemorrhage.
Borrowed a car from, but at the time of accident,
Somebody is disturbing.
Yes. Yes.
8,000 has taken income.
Yes. Yes.
He was doing tailoring work and earning a sum of rupees 20,000 per month. And same has been deposited by
Yes.
PW1. And he was cross-examined by the respondent and nothing has been elicited to disprove the avocation or the permanent disability. Doctor has stated 33% permanent physical disability. And there is no question of one-third. He ought to have been taken the disability at 33%.
Where is that evidence of that? Then you will secure the records. Yes. Heard. Admit.
My lord, I am for
Yes.
the appellant, my lord. Appeal by the
Yes.
BMTC charging negligence and quantum of compensation awarded by the
Yes.
tribunal. I have ready to deposit 50% of the award amount before High Court.
Yes. Heard. Issue notice. Stay of judgment and award dated 4th March 2022. Passed by MACT Bangalore in MEC 4161 of 2020. Subject to condition. Appellant has to deposit 50% of the award amount with interest within 4 weeks from today. Quantum.
Before High Court, my lord,
Why?
you asked me this court on Thai.
Before this court. Yes. Damages. What is the vehicle? Ian vehicle, right? Car. Ertiga na? Or Honda? Yes. Or issue notice. Stay of judgment and award dated 23rd March 2022.
High Court.
MEC Bangalore in MEC 527 of 2019. Subject to condition. Has to deposit 50% of the award amount with interest within 4 weeks from today before the tribunal. Yes, Vishwanath.
Lord petitioner by me, Lord petitioner, my lord, was
Yes.
respondent number 4 in the writ petition, my lord. Lord, he was,
Yes.
counsel did not represent, my lord, the matter. Lord, the fact that, my lord, he
Yes.
was in possession, my lord, pursuant to the order of the deputy commissioner, dismissing the appeal filed by the
Yes.
Lord was not.
Jagdish, ಇದಾದ್ಮೇಲೆ move ಮಾಡೋಣ.
There is some disturbance.
Yes.
Lord, the fact that, my lord,
Yes.
petitioner, my lord, original grantees LR was put in possession of the property, my lord,
Yes.
after the pursuant to the deputy commissioner's order, my lord, was not placed before my lords. Lord, the Honorable Supreme Court in 94 SEC, my lord, has stated, my lord, each case will have to be examined, my lord, on its own merits and facts of the case. Lord, so as to, my lord, the kindly see, my lord, the beneficial legislation of the SC/ST Act, my lord, has to be given, my lord, the real, my lord, effect and meaning. Lord, your lordships may kindly direct
Yes.
notice to respondent number 4, my lord, so that, my lord, matter could be disposed of.
No. On what? See, it is what that, see, following that Supreme Court judgment.
Yes, my lord. Lord, Lord, the one.
There is a.
Yes.
Yes.
Lord, in
following that Supreme Court judgment.
Yes, my lord. In that Supreme Court judgment, my lord, the earlier judgment of the Honorable Supreme Court in 1994, 3 SCC, page 536, a 3-judge bench, my lord, of Justice A.M. Mahamati, Justice Yogeshwar Dayal, and Justice N.P. Singh, K.T. Huchegowda versus Deputy Commissioner and others.
Yes.
which said, my lord, each case will have to be considered, my lord, on facts to determine limitation, whether limitation was there or not, whether it was barred by limitation. Now, period of limitation for perfecting title,
Yes.
continuous enjoyment would be 12 years where the land granted by government with absolute ownership, and 30 years where land granted by way of allotment without transfer of ownership in favor of the grantee. In this case,
No. That is no, not on that point, Mister. But the point is to invoking that provision.
Lord,
he should have invoked within that reasonable time. That is what that
Lord, within
Nikanti Rama Lakshmi case Supreme Court said.
Lord,
It is not that regarding that adverse position.
Yes,
this is the case where you have to initiate that proceedings within reasonable time. That is what the Supreme Court said. On that ground, it is dismissed, Mister.
Yes,
not on the ground that you are in the possession.
Lord, I will just point out, my lord, in this case, my lord, the grant was free of cost on 17/3/1981.
Yes.
Okay, 15 years non-alienation.
Yes.
The erstwhile my lord, grantee, my lord, has sold the land on 6/4/1996.
Yes.
Application for restoration was filed in 2006, my lord, before the assistant commissioner.
Yes.
Lord,
yes.
application was allowed on 21/12/2009.
Yes.
Lord, an appeal was filed by the fourth respondent before the commissioner on 3/8/2012, and it was dismissed on the same day. On 3/8/2012 itself, it was dismissed.
Yes.
Lord, immediately, my lord,
no, that is.
Yes, my lord, I just point out, my lord, the dates. Thereafter, my lord, I will just take your lordship to the legal aspect.
No, you need not go for that further date. The day you have invoked after 9 years.
Lord, kindly appreciate, my lord. In after 2012, my lord, the appeal was dismissed on 3/8/2012. In December 2012, my lord, I have been put in possession. The land revenue entries have been effected in my favor.
No, that is not the concern of this case, Mister. The case is that on 1996 you have filed an application that you have sold that land.
Yes,
you have filed an application in the year 2006.
Lord, yes, my lord.
After lapse of 9 years.
Yes, my
lord. That is what that on that ground.
Lord, now, my lord.
The application itself is not maintainable if it is beyond some reasonable time.
Lord,
that is what Supreme Court said.
Lord, in another judgment of the Honorable Supreme Court, my lord, I just pointed out 1994 3 SCC. Honorable Supreme Court, judge bench of the Honorable Supreme Court said, my lord, in each case, and this also arose under the SC/ST Act itself, Karnataka SC/ST Act, where the Honorable Supreme Court said, my lord, each case will have to be examined on its own merits, my lord. Lord, para 10, my lord.
Each case was examined for what purpose?
Lord, to show, Lord, that on the facts of the case, my lord, the respondent number 4 was not entitled for an order. The order passed by this honorable court has been obtained, my lord, without bringing to the notice of the court, my lord, that the purchaser was dispossessed from the land. The original grantees LRs were put in possession.
No, that is not the case, Mister. Even if they have been dispossessed, they can be restored back if that initiation itself is without jurisdiction.
Lord,
just because the position has been restored, their right has not been curtailed, Mister.
Lord, neither in Nekanti's case, my lord, or in Chedilal's Yadav, my lord, such a restoration was there, my lord. In those cases, my lord, it was
no. That's no for that they will approach and get it. No, if you are in the position, they will approach for for civil court and restoration of the position.
No, that is a difficulty, my lord.
That is different. We are not say that for dispossession.
Lord, when this honorable lord passes an order, my lord, civil courts, my lord, cannot overrule that order. That is the difficulty I am placed in. Your lordship.
No. We have for taking the possession. They have to approach for on the basis of that they have become owner now. Lord, they can for the possession they can buy there.
Not based on this order, my lord.
Even
number 4 is trying to make the revenue entries in his name. and my lord, take over possession, my lord, from the petitioners, my lord. That is the difficulty, my lord. Now they are not going to the civil court. When your lordship, my lord, passes an order, my lord, my lord, the high court's order, my lord, would
That is not concerned with this court, Mr. Here is the only a case they have urged that you have invoked that section 4
yes, my lord.
beyond limitation. Now Supreme Court said if he has invoked beyond limitation,
Yes.
the order which is passed without jurisdiction.
My lord, in each case, my lord, the facts, my lord, will
Now, what facts he has to be seen by each case? What is the difference? Delay is the same.
Lord, the question of delay, my lord, will have to be appreciated, my lord, with regard to the fact that, my lord, as on the date this honorable court passed the order, my lord, the purchaser was not in possession of the property at all.
No, that is immaterial, Mr. That is immaterial. On the basis of that order passed without jurisdiction, you have been put in the possession.
That is the ground, my lord, which I have urged, my lord, for this review petition, my lord.
Yes.
May kindly direct notice to respondent number 4, my lord, and decide the main matter itself, my lord.
Now, what is that use in that, Mr.?
Lord, Lord,
If you want to place, if you want to argue by physically, I will grant time. You come and argue. I will hear and dispose of.
Lord, your lordship may have it after
21.
5th, my lord. Your lordship may have it, my lord. July 4th or 5th, your
Yes.
lordship may have it, my lord. I will come and address argument.
Yes, at the request of counsel for appellant, at the request of counsel for the petitioner, release this matter of 2 weeks. Yes.
Right.
Yes, Mr. What is this, Mr.? Oh, land has been, yes. 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 Where is Shuram? No, 2 acres has been granted. You have sold only 1 acre 20 guntas. Now, what is the order of the AC and DC?
Restoration order was passed. That has been discussed by your lordship.
No.
But the order will not lordship consider the entire irrigation for 2 acres instead of 1 acre.
Will have more than 34 in filing application. Yes, where is he? Also, we get him. Get that Shuram. Yes, just inform him that none appear for respondent number 1 to 4. As a last chance, release this matter next week. Otherwise, we'll next Friday. Yes. Otherwise, I will recall it and post it before the regular bench. Yes.
With your lordships kindly, my lord.
Yes.
Pass over matter, 1 matter.
Passover will take 2:30. Yes. 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 On what ground you are challenging, Mr. Involvement of the vehicle? Yes. Let us see. Let him argue. Yes. Yes, Mr. What is the date of the accident? 4/2/2012. Oh, is it case of injury? How that accident has occurred on 1/12. Petitioner was traveling in that Bolero Jeep bearing registration number of purchasing previous home. She was shifted to also. The road suddenly that carriage came across the road. Respondent, which is that vehicle? Jeep. Opposite vehicle? checking the right side of the road while jeep was in proceedings near the so also. But all of a sudden, cattle came across the road and responded who was driving that vehicle all of a sudden. Now that it is a comprehensive policy. Then inmates are covered. Yes. Now that your case is that there was no involvement of yes, but when that complaint has been lodged, same day. 13 days. Yes, yes. Now we'll come to that. Where is that first hospital records? Yes. Alala, what is the entry in that hospital? History of road traffic accident. History is that road traffic accident. Yes. It was entered on the same day. 4-2. Jeep upside down. Yes. I am of the opinion that the above said injuries grievance in nature so on. Yes. Yes. Why? No, PW1 is the injured. No, is it a lady? What is the name of the injured? Lady. Yes. Now that whether it is driving by her husband or that brother-in-law, how it will make? Alalala. No, how it will improve your case? If it is driving by his husband, it will not make any difference for you. Alva, alala, you submit. I thought that injured himself was driving. Jeep. ಅಲ್ಲಿಗೆ ಗಂಡ ಆಗ್ಲಿ ಅಥವಾ ಅವ್ರ ಭಾವ ಆಗ್ಲಿ ಏನು ಅದರಲ್ಲೇನು there is no dispute. No, because you have raised that point, therefore I. Yes. Yes. ಅಪಘಾತ ನಡೆದ ತಕ್ಷಣ ದೂರು ನೀಡದೆ 13 ದಿನ ತಡವಾಗಿ ದೂರು ನೀಡಲು ಏನು ಕಾರಣ ಎಂದು ಹೇಳಬಹುದು ಎಂದರೆ ಸಾಕ್ಷಿಯು ತಕ್ಷಣ ದೂರು ನೀಡಿದ್ದೆವು ಎಂದು ಹೇಳುತ್ತಾರೆ. Documents ಇಲ್ಲ ಬಿಡಿ. They have not produced that any such application.
ನನ್ನ ಗಂಡನ ಬಳಿ ಕಾಲಿ ಅಪಘಾತ ನಂತರ ನನ್ನನ್ನು ಮೊದಲು ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ನನ್ನ ಭಾವ ಅಂದರೆ 15 ದಾಖಲೆಯ ಪ್ರಕಾರ ನನ್ನ ಗಂಡ ರಮೇಶ್ ನನ್ನ ಕಾಲಿಗೆ ಹೊರತುಪಡಿಸಿ ಬೇರೆ ಲಾಸ್ಟ್ ನನ್ನ ಕಾಲನ್ನು ಹೊರತುಪಡಿಸಿ ಬೇರೆ ಯಾವುದೇ ನಾನು ನನ್ನ ಭಾವ
Yes.
ಅದು ನಮ್ಮ ಸೆವೆನ್ ಆಫ್ ದಿ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ LMB ಈ ತನಕ ಇದೆ ಅಂದ್ರೆ 4 ಇಸ್ವಿನಲ್ಲಿ 26/2/2004 ಎಕ್ಸೆಟ್ ಆಗಿರೋದು 4/2/2004.
Yes. Yes. Who is appearing for the owner? ಅಲ್ಲ ಇಲ್ಲಿ ಲಾಯರ್ ಯಾರು ಅಂತ ಅವ್ರ ಭಾವ ಅಳಿಯ ನಾವೇನ್ ನಮಗೇನು ಅವೇನ್ ಭಾವರ ಅಳಿಯ ರೆಪ್ರೆಸೆಂಟ್. ಎಸ್, ಎರಡರಲ್ಲ ಸರ್ಡ್ ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್. There is no other this thing. What is the finding of the tribunal regarding the DL? Yes. Yes. Yes, mister. What to say about the DL? Anyhow, that it is your, it may be. ಏನ್ ನೆಗೆಟಿವ್ ಯಾಕೆ ಹೇಳಿದ್ದಾರೆ? Respondent proved that defendant number was not holding valid and effective driving license. What is the discussion for issue number 2? Respondent contended that does not valid driving license. Exhibit police notice because that respondent had valid license too. Exhibit P1 ಎಲ್ಲಿದೆ? Exhibit P1 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ? That is wrong finding. This finding is wrong by the tribunal. Yes, Vasudev Rao Varsha. LME ಎಲ್ಲಿದೆ? ಅದೇ ಲೈಸೆನ್ಸ್ LME ಆದ್ರೂ ನಡೆಯುತ್ತೆ, ಬಟ್ ಇಟ್ ಇಸ್ ಫಾರ್ ಓನ್ಲಿ 2004. ವಿಮೆ ಪಾಲಿಸಿ ದೃಢೀಕರಣ ಪತ್ರ ಮತ್ತು ವಿಮೆ ಪಾಲಿಸಿ ಊರ್ಜಿತ ದಿನಾಂಕ, ವಿಮೆ ದೃಢೀಕರಣ ಪತ್ರ, ವಾಹನ ವಿವರ, ವರ್ಗಾವಣೆ ಅನುಮೋದನೆ. ಕೂಡಿಗೆರೆ ವಾಸುದೇವ್ ರಾವ್ ಅವರು ವೆಂಕಟರಾಯ್ ಅವರು 55 ವರ್ಷ ವಾಸ ಕೂಡಿಗೆರೆ ತಾಲೂಕು. ಎಲ್ಲಿದೆ? ಎಲ್ಲಿದೆ ರೀ ಡೇಟ್? ಡೇಟ್ ಇರ್ಬೇಕ್ರಿ. ಎಲ್ಲಿಂದ ಎಲ್ಲಿ ಅಂದ್ರೆ ಡೇಟ್ ಆಗ್ತಿಲ್ರಿ. DL ಹೆಂಗ್ರಿ? ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇವರ ಚಾಲಕರ ಹೆಸರು ಎಲ್ಲೈತ್ರಿ? ಈ ವಾಸುದೇವ್ ಅವರ ವೆಂಕಟ ಯಾವ ರೀತಿಯ ಲೈಸೆನ್ಸ್ ಅಧಿಕೃತವಾಗಿ ನೀಡಲಾಗಿದೆ? LME. Yes, there is no such distinction. Evidence Allah, tribunal has given a wrong finding saying that exhibit P1 is the driving license. That is wrong because it is not there as on that day. There is no finding on that point. Yes. See that 2 lines finding given by the tribunal on perusal of the exhibit P1, the police notice reveals that respondent number 1 has a valid driving license. Exhibit P1 ಏನಿದು police notice ಇದು? ಇದರಲ್ಲಿ ಎಲ್ಲಿದೆ? ಏನ್ ಪೊಲೀಸ್ ಏನಂತ ನೋಟಿಸ್ ಕೊಡ್ತಾರೆ? ಯಾಕೆ ನೋಡಿ ಏನು ವಾಟ್ ಇಸ್ ದಟ್ ನೋಟಿಸ್? Yes, you don't have any driving license. Yes. Yes. No other document has been produced. Allah. Allah. Except that there is no other document is there. So Bini, is there any other document? Then there is no document to show that he was in a driving license as on that day. Yes. Then now that what is that quantum? A date of accident? Well. Yes. ಎಲ್ಲಿದೆ 40? Yes. No, we'll see that the evidence of the doctor. Where is that doctor? Where is the discussion regarding the disability? Discussion is on page number. Para. Mannappa Naik has the opinion that difficulties to that walk and so and so, right great amputations. Doctor the evidence. Yes. But amputations come and skin grafting of yes. Disability proper. Criminal must be addition 40% to the actual income of the victim. Tribunal error consider ಮಾಡಿದ್ದಾರೆ. Where is the discussion of it? Huh? Hmm. 10% ತಗೊಂಡಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್ ಅವರು 10% ಗೆ 40% ಆಡ್ ಮಾಡಿದ್ದಾರೆ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ 10% ಗೆ ಎಲ್ರಿ ಗೊತ್ತು no. If it is above 50% whole body ತಗೊಂಡ್ರೆ then we are giving 10% ಗೆ ಎಲ್ರಿ ಬರ್ತದೆ. If it is amputation, why the 10 only 10%? ಎಲ್ಲಿದೆ amputation ಅಂತ ಅಲ್ಲ that will see. Your appeal is there. If you show that it is an amputation, why the tribunal has taken 10 then? ಯಾವ್ದು amputation ನೋಡೋದು ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್. Otherwise, tribunal would not have taken 10% to start. ಆಯ್ತ್ರಿ ಇಲ್ಲಿ ಟ್ರಿಬ್ಯುನಲ್ ಯಾಕೆ 10% ತಗೊಂಡಿದ್ದಾರೆ? In view of the principle laid down in the decision, victim has below 40 years, addition 40 to the actual income. ಡಾಕ್ಟ್ರೆ 10% ಅಂತ ಹೇಳಿದಾರ? ಡಾಕ್ಟರ್ said 10%. It is not true suggest that disability of 10% will be reduced when compared to that whole body. Yes, Mr. Doctor itself has 10%. How can that 40% ಯಾರು ತಗೊಂಡಿದ್ದಾರೆ? Each prospects. ಅದಕ್ಕೆ ಬರೋಣ. So first, let me confirm that for disability, then I will come to that. Because his appeal is also there. He is saying that amputation, therefore I am surprised why that doctor said that. Post. Doctor himself said 10. Doctor himself said 10%. Yes. 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 We'll consider. Yes. $4,000. 2012 ಗೆ ಎಷ್ಟಿತ್ತು? 12 ಗೆ 7,000. ನೀವು ಎಷ್ಟು ಇನ್ಕಮ್ ಅಂತ ಹೇಳಿದ್ರಿ? 10,000. First, one by one. Where is that discussion on this? Minister has claiming that she is doing an old work and maintaining the daily so. Monappa Nayaka is opined that petitioner facing a difficulties in walking, facing due to that walk. Because that great toe is amputated. There was a crush. It is also looking very high. So petitioner do hold activity tailoring. The petitioner has sustained 10% in respect of right lower limb. Entitled great specialties. So. Yeah. Now, where is that doctor has said how much for future medical expenses? Yeah, where is that? You show me that evidence. Has said what is that future medical expenses required? Lot of immunity, attendance, pain and lot of earning. Medical expenses. Huh? Yes. attendance charges, loss of immunities. He has given sufficiently. ಇದು ತಗೊಳ್ಳಿ. $7,000, 10%. 15 multiplied. Percent is at 1,26,000. Yes. Yes. Doctor Kinta, we can't go beyond what doctor said, Mr. He is an expert. Yes. No, doctor evidence is there. Yes, that's all. Yes, what do you say about that, this thing, driving license? Yes. Now that finding is wrong. Yes. Yes. Yes, really. See, Savish Binny, Bernard Council appearing for the insurance company has contended that the offending vehicle bearing registration number KA18M5181 yes, was not involved in that accident. The claimant has collided with that owner of the offending vehicle and implicated that vehicle for making a false claim. He contended that the complaint has been lodged after 13 days from the date of the accident, and the claim petition has been filed after 3 years from the date of the accident. He further contended that the claimant has not filed IMA report or MLC extract to prove that they have suffered an injury due to that accident occurred by the negligence of driver of the offending vehicle. The tribunal has error in held that offending vehicle was involved in the accident. He further contended that the driver of the offending vehicle was not having valid and effective driving license. The tribunal has, the insurance company has taken a specific contention. The tribunal has given a finding that as per Exhibit P1 police notice, the driver of the Jeep has valid effective driving license. As per the Exhibit P1, the validity of the license has been shown till 26/2/2004. The accident was occurred on 4/2/2012. Therefore, the finding of the tribunal is contrary to the material available on record. Since insured has violated the policy condition, the insurance company is not liable to pay that compensation. In respect of quantum, he has contended that the injuries suffered by the claimants are minor in nature. Only that amputation of great toe the doctor has assessed the whole body disabilities is 10%. The tribunal has added 40% of the income of the claimant for future prospects is not called for, since the disabilities is only 10%. There is no functional disabilities. Lastly, he has contended that the injuries suffered by the claimants are minor in nature. She was inpatient, yes, Dina. Inpatient only for 20 days. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on higher side. Hence, he sought for allowing the appeal filed by the insurance company. Shri Vinod Gowda, learned counsel appearing for the claimant, has contended that the accident is occurred due to the rash and negligent driving of driver of jeep bearing registration number K18 M5121. Immediately after, the claimant is admitted to which hospital? Exhibit P1 wound certificate. Exhibit P4. Which hospital? Government hospital. Balevale Government Hospital. As per Exhibit P4 wound certificate, the specifically mentioned that history of road traffic accident, jeep upside, and it has been entered on 4/2/2012 itself. Since the claimant has suffered an injury, she was unable to lodge a complaint immediately. Therefore, there is a delay of lodging the complaint. He further contended that the respondent has not examined any witnesses to disprove the evidence of the claimants. Therefore, even the police is registered FIR against the driver of the offending vehicle. Charge sheet ilva? Yes. Therefore, it is very clear that offending vehicle was involved in that accident. In respect of DL is concerned, he has contended that even if this court held that driver of the offending vehicle was not having valid and effective driving license, in respect of claimant is concerned, the insurance company has to pay that compensation amount with liberty to recover from the owner of the offending vehicle. To that effect, he has relied on judgment of apex court in case of Poppu. In respect of quantum, he has contended that due to the accident, at the time of the accident, she was working as she was doing a tailoring and maintaining dairy and vending the milk. Due to the amputation of her great toe, she was unable to do her day-to-day work. Therefore, the tribunal has rightly awarded future prospects. He further contended that at the time of the accident, she was earning 10,000 per month. The tribunal has assessed notional income of the claimant as 4,000 is on lower side. Lastly, he has contended that the injuries suffered by the claimants are the claimant has suffered a grievous injury. She was inpatient for a period of 20 days. She has suffered a lot of pain during the treatment. She has to suffer this disability and unhappiness throughout her life. Therefore, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, she sought for enhancement of compensation. The owner of the vehicle has been served unrepresented, or the learned counsel for the claimant as well as counsel for insurance company. The case of the claimants that on peruse that original records. On 4/2/2012, at about 3 p.m., she was traveling in a jeep bearing registration number K18 M5121 from Gaurashuk Kodigi to Balehole. When the jeep proceeded near the point of Gorosu Kodige, Balehole, at the time, suddenly a stray dog come across the road. The respondent number 1 who was driving the vehicle all of a sudden took the jeep right turn in order to avoid hitting the stray cattle. Avoid hitting the cattle. Due to that, the jeep was toppled. Consequently, the claimant has suffered a right foot. Her right foot was crushed. Immediately, she has shifted to PHC Hospital Balehole, where she has taken a treatment as inpatient. To prove the case, the claimant has examined as PW1. She has categorically stated that the accident is occurred due to the negligence of driver of the offending jeep. Immediately after, she has been shifted to government hospital Balehole. As per exhibit P4, it has been mentioned that history of road traffic accident, the jeep upside. The entry has been made on 4/2/2012 at about 4:30 p.m. 3:30 p.m. Even respondent has not elicited any worthwhile from cross-examination of PW1. PW2. Even the complaint has been lodged against the driver of the jeep. As per exhibit P3, the police has registered an FIR against the driver of the jeep as per exhibit P2. To disprove the case of the claimant, the respondent has not examined any witnesses. Considering that evidence of PW1 and considering that FIR complaint wound certificate, the tribunal is justified, held that justify in answering issue number 1, affirmative. In respect of quantum is concerned, even though the claimant has claimed that she was earning 10,000 per month and she has produced ಏನದು exhibit P6 ಏನದು ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯ ಬಂದಿತ್ತರದು ಕೇಸ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಏನೋ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಬಂದಿತ್ತರೋ ಜೀವನಾಧಾರ ಹಣ ಮತ್ತು ಸಾಕ್ಷಿ ವೆಚ್ಚದ ಇದು ದುಡ್ಡೇನ ಕಟ್ಟಿರೋದಕ್ಕಲ್ಲಿ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಅದೇ ಇದು ಪೊಲೀಸ್ ರೆಕಾರ್ಡ್ಸ್ ಇದ್ರದ್ದು ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹಣ ಕಟ್ಟಿರೋದು exhibit P6. Yes. ಏನಂತ ಹೇಳಿದ್ರು? They has not produced any document to establish that income. Therefore, notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring in 2012, the notional income has to be considered as 7,000. The tribunal, after considering the evidence of the doctor, has rightly assessed the whole body disabilities as 10%. Due to that amputation of right great toe, There is no any such functional disability. Therefore, the claimant is not entitled for future prospects. The multiplier applicable to that age group is yesterday. Multiplier is 15. 15. What is her age? 40. 40, 15. 38. Yes, 15. Yes. The loss of future earning has been reassessed as follows. ಅಲ್ಲಿಗೆ even future prospects ಆದ್ರೂ it will come to that same 20,000 ಜಾಸ್ತಿ ಆಯ್ತು. Due to that extent, the claimant has suffered grievous injury. He was inpatient for a period of 20 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, considering that injury suffered by the claimant, I am of the opinion that the compensation awarded by the tribunal for pain and suffering is on higher side. The same has to be reduced to 75,000 from 1 lakh. For loss of immunities has to be enhanced from 25,000 to 40,000. Attendance charges and nourishment has to be considered enhanced from 10,000 to 20,000. Loss of income during the later period has to be awarded for 6 months. 6 months ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ 6 months. Interest? Yes. In respect of liabilities is concerned, future prospects ತಾಂಡಿಲ್ಲ ಬಟ್ ಸೇಮ್ 20,000 ಜಾಸ್ತಿನೇ ಆಗಿದೆ. ಇದರಲ್ಲೂ 20,000 ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಅವ್ರು 1 ಲಕ್ಷ ಬಂದಿದೆ, ನಮ್ದು 1,26,000 ಬಂದಿದೆ. In other hand, I have increased, overall it is increased, but liabilities is concerned. The insurance company has taken a specific contention that driver of the offending vehicle as not having valid and effective driving license. The police is also issued a notice. The owner of the offending vehicle has not produced any driving license to prove that he is having valid driving license as on the date of the accident. Even as per that, the tribunal has only on the basis of exhibit P, exhibit P1 held that the driver is having a valid effective driving license. As per exhibit P1, the validity of the driving license has been mentioned till 26/2/2004. The accident was occurred on 4/2/2012. Therefore, the finding of the tribunal is perverse, contrary to the material available on records. There was no driving license as on the date of the accident as per exhibit P1. Therefore, even before this court, the owner is served. Even the insurance company has taken a specific ground in the appeal that driver of the offending vehicle was not having valid effective driving license. In spite of service of notice, the owner of the offending vehicle was not appeared before this court, has not produced any document. Therefore, adverse inference has to be drawn that driver of the offending vehicle was not having valid and effective driving license as on the date of the accident. In respect of third parties is concerned, if in view of judgment of apex court in case of Popo, the insurance company has to pay that compensation amount to the third party with liberty to recover from the owner of the offending vehicle. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. The insurance company is directed to deposit entire compensation amount with interest within 6 weeks from date of receipt of the copy of this order, with liberty to recover from the owner of the offending vehicle. Amount in deposit is transferred to the president. In view of order dated 9/6/2022, the claimant is not entitled for the interest for a period of 776 days. Entire amount is transferred. Yes. Next week ಹೋಗಿದೆ. Here there is only sale is only in respect of 1 acre 20 guntas. Yes, we verify on that, then otherwise I will just clarify. No, sale itself is for 1 acre 20 guntas. It cannot be more than that. Yes.
ಕೋರ್ಟ್ ಹೌಸ್ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 71 ಇದೆಯೇನ್ರಿ? ಕೋರ್ಟ್ ಹೌಸ್ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 71 ಅರ್ಜನ್ ಇದೆಯಾ? ಕೋರ್ಟ್ ಹೌಸ್ ಸರ್ ಕೋರ್ಟ್ ಹೌಸ್ ಸರ್ ಕೋರ್ಟ್ ಹೌಸ್ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 71 ಇದೆಯೇನ್ರಿ?
71 ಬೆಳಗ್ಗೆನೆ ಅರ್ಜನ್ ಆಗಿದೆ.
ಬೆಳಿಗ್ಗೆನೆ ಆಗೋಯ್ತು ಅದನ್ನು.
ಹೌದೌದು
70 sir, 70
ಇದೆ ಸರ್.
Okay, thank you.
Live. ದೊಡ್ಡ ಜಾಗ ಮಾಡ್ಕೊ. ಹಾ
Court officer? Court officer? Court officer ಅವರೇ?
ಸ್ವಾಮಿ ಇನ್ನು ಯಾರು ಬಂದಿಲ್ಲ, ವೇಟ್ ಮಾಡಿ.
ಆಯ್ತು.
Court officer. Court officer.
ಹೇಳಿ ಸರ್.
ಗುರುರಾಜ್ ವಿ ಹಾಸಿಲ್ಕರ್ SGP ಕಲಬುರಗಿ.
ಓಕೆ ಸರ್, ಓಕೆ ಸರ್. DB ಇದೆ ಸರ್, ಅದು ಮುಗಿಸ್ಕೊ ಬರ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ನಿಮ್ದೇ ತಗೋತಾರೆ ಫಸ್ಟ್.
ಆಯ್ತಾಯ್ತು.
ಓಕೆ.
Court officer.
ಹೇಳಿ ಸರ್.
Matter pertaining to Kalaburgi bench.
ಹೌದು ಸರ್, DB ನಡೀತಾ ಇದೆ. ಅದು ಮುಗಿದ ತಕ್ಷಣ ಬಂದು ಕಲಬುರ್ಗಿ ಬೆಂಚ್ ತಗೋತಾರೆ ಸರ್ ಫಸ್ಟ್.
ಎಷ್ಟೊತ್ತಾಗ್ಬೋದು ಸರ್?
240 ಆಗ್ಬೋದು ಸರ್, ಹೆಚ್ಚು ಕಡಿಮೆ. ಓಕೆ ಸರ್.
Mahesh, 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 ಯಾಕೆ ಮೈಗೂ ಸೇರ್ಲ್ವಾ? ಹಾ,
ಅದು ನೀರು ಕುಡ್ದಿದ್ ಗಂಟ್ಲಿಗೆ ಇದಾಗಿದೆ.
ಓಕೆ.
Cost of income will be made up to 19,500 against for cost of income, cost of future income. Compensation. Yes. Another case, all other cases, financial system, simple injuries, or the local the payment was admitted as inpatient in hospital from 27 to 11. If there is no disability, including the one of the state communities of extent of our the good ambulance awarded 24,300. And also consider that there is no stability. Okay, for respondent pillar. Yes. What is it? Forget about ಅತನ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ just a second. The payment was coming in previous time. It was it by then on that you are ran over to it. Next. Previous time was dashed by Apariksha on the back side. Apariksha, previous time ran out. Then what happened? Just a second. Or it dashed on the previous time. After? Or it dashed against previous time covered down and auto. Just stop. Anandra? So that is previous time on the back side. Previous time fell down. Then Monday or Anandra first. Only in sequence.
Sir, Gulbarga bench advocate ready idira? Sir, Kotal 16 inda.
Sir, na SGP.
Sorry, sir.
ಆಮೇಲೆ ಪೆಟಿಷನರ್ ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರೆ.
Okay, okay, sir. Kalburgi bench matter for order serial number 1, SP Sangolagi for petitioner, SM Patil SC60.
No, I am for respondent, my lord.
My lord, I am for petitioner.
Yes. Where is Patil?
Patil and Guraj Vyasukere, SGP, my lord.
Yes.
My lord, this is person under section 438 of CRPC.
Yes.
The alleged offense is 498A and 306.
Yes.
My lord, in my previous approach,
Yes.
my lordship have observed while granting the bail to the accused number 1, accused number 2, that is the father of the petitioner.
Yes.
My lord, against the accused number 2, there was flat omnibus allegations.
Yes.
That is in, reflected in page number 28, my lord, previous order.
Page number?
28, my lord.
Oh.
There is no specific any allegation against the petitioner number 2.
Complaint, there is some allegation against that accused number 1.
Yes, my lord. But in the entire charge sheet,
yes,
absolutely there is no specific allegation. Cruelty and harassment regarding what, my lord?
No, you
Nothing.
see that charge.
Yes,
See the
my
charge.
my lord. Column number 17, my lord. May I read with permission of the honorable court?
Yes.
I have filed charge sheet that is in page number 3. Charge sheet column 17.
Yes.
My lord, may I read?
Yes.
ಮನವಿ ಮಾಡಿಕೊಳ್ಳುವುದು ಏನೆಂದರೆ ಈ ದೋಷಾರೋಪ ಪತ್ರದ ಕಾಲಂ 14ರಲ್ಲಿ ನಮೂದಿಸಿದ ಫಿರ್ಯಾದಿ ಸಂಖ್ಯೆ 1 ಅವರ ತಂಗಿ ಮತ್ತು ಸಾಕ್ಷಿ 12ರ ಮಗಳಾದ ರಮಾಬಾಯಿ ಒಳಗೆ ದೋಷಾರೋಪ ಪತ್ರ ಕಾಲಂ 12ರಲ್ಲಿ ನಮೂದಿಸಿದ ಆರೋಪಿತನೊಂದಿಗೆ ಮದುವೆ ಮಾಡಿ 15 ವರ್ಷ ಆಗಿದ್ದು ಆರೋಪಿತನು ತನ್ನ ಹೆಂಡತಿ ರಮಾಬಾಯಿ ಒಳಗೆ ವಿನಾಕಾರಣ ಆಗಾಗ ಕಿರುಕುಳ ಕೊಡುತ್ತಾ ಹೊಡೆ ಮಾಡುತ್ತಿದ್ದಾಗ ಈ ಬಗ್ಗೆ ರಮಾಬಾಯಿ my lord, for what reason, whether he is demanding money, whether he is an alcoholic, whether he is making allegation against the deceased, she is not looking fair, she is not cooking properly, nothing is there, my lord.
Yes.
Allegation, he is giving harassment and cruelty since from the date of marriage.
Yes.
My lord, and I would like to bring the notice of the honorable court. In the last day I have submitted that the daughter of the petitioner as well as deceased, that is Kumari Yashoda.
Yes.
In page number 16, the first 161 statement, and page number 17, her further statement.
Yes.
My lord, in her 16, page number 16, her first statement,
yes,
she have made allegation against her father and grandfather. Both
yes,
were giving harassment and cruelty to her mother, due to which
yes,
their mother committed suicide by hanging with a sari.
Yes.
And very interestingly, on her further statement that is recorded on 11/6.
Yes.
in her further statements, she has stated that her grandfather have not given any cruelty and harassment.
Yes.
Only father have given cruelty and harassment, due to which committed by hanging with rope, my lord.
No, that is what that allegation is there against you. There is no changes.
For what reason the petitioner have given harassment? Nothing is there, my lord. Nothing is there. Only flat allegation.
Allegation is that 498A.
My lord, 498A, that cruelty and harassment must lead to commit suicide the victim. For what reason, my lord? Nothing is there. Neither he demanded additional dowry, nor he is an alcoholic, nor he made any allegations he is not cooking properly, and not have made allegations he is not looking good. Nothing is there. And even he is not suspecting her character. Under that circumstance, what is the reason for giving the cruelty and harassment? Nothing is there, my lord. And he is
Where is the Mr. Counsel? Where is that complaint copy?
My lord, that is in
12, my lord.
page number 12, my lord, in my main petition, page number 12, my lord.
Page number 12. Yes.
He is the brother of the deceased, my lord.
Yes.
He has lodged the complaint. May I read the complaint?
Yes.
ನಾನು ರಜನಿಕಾಂತ್ ತಂದೆ ಶ್ರೀಮಂತ್ ಸುತಾರ್ ಇದು ಈ ಅರ್ಜಿ ಮೂಲಕ ವಿನಂತಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ, ನನ್ನ ತಂಗಿ ರಮಾಬಾಯಿ ಅವರಿಗೆ ಜಾಪೂರ್ ಗ್ರಾಮದ ಅಣ್ಣಪ್ಪ ತಂದೆ ಬಸವರಾಜ್ ಕಟ್ಟಿಮನಿಯವರೊಂದಿಗೆ 15 ವರ್ಷಗಳ ಹಿಂದೆ ಮದುವೆ ಮಾಡಿಕೊಟ್ಟಿರುತ್ತೇವೆ. ಇವಳಿಗೆ ಈಗ 5 ಜನ ಮಕ್ಕಳು ಇರುತ್ತಾರೆ. ನನ್ನ ತಂಗಿಗೆ ಗಂಡ ಮತ್ತು ಮಾವ ಇವರು ವಿನಾಕಾರಣ ಪದೇ ಪದೇ ದಿನನಿತ್ಯ ಮಾನಸಿಕ ಮತ್ತು ದೈಹಿಕ ಕಿರುಕುಳ ನೀಡಿ ಹಿಂಸೆ ನೀಡುತ್ತಾ ಬಂದಿರುತ್ತಾರೆ. ನನ್ನ ತಂಗಿ ಎಲ್ಲ ದಾಳಿಕೊಂಡು ಬಂದಿರುತ್ತಾಳೆ. ನನ್ನ ತಂದೆ ತಾಯಿಯವರು ಮಹಾರಾಷ್ಟ್ರ ಪುಣೆ ನಗರದಲ್ಲಿ ಇರುತ್ತಾರೆ. ದಿನಾಂಕ 18/5/2020 ನನ್ನ ತಂಗಿಗೆ ಅವಳ ಗಂಡ ವಿನಾಕಾರಣ ಕಿರುಕುಳ ನೀಡುತ್ತಿದ್ದಾರೆ ಅಂತ ನನ್ನ ತಂದೆ ತಾಯಿಯವರಿಗೆ ಮೊಬೈಲ್ ಮುಖಾಂತರ ತಿಳಿಸಿರುತ್ತಾಳೆ. ಆಗ ನನ್ನ ತಂದೆಯವರು COVID-19 ರೋಗ ಇರುವುದರಿಂದ ಲಾಕ್ಡೌನ್ ಇದ್ದು ಯಾವುದೇ ವಾಹನಗಳು ಇರುವುದಿಲ್ಲ, ನಿನ್ನ ಸಮಸ್ಯೆ ನಂತರ ಪಂಚಾಯತಿ ಮಾಡಿ ಬಗೆಹರಿಸುತ್ತೇವೆ ಎಂದು ಹೇಳಿರುತ್ತಾರೆ.
It has been last occasion even that session court has rejected your bail. High court is also rejected. We have not surrendered for conducting an investigation. Last 2 years you are absconding.
My lord, my humble submission before the honorable court is
even after rejection.
My lord, once I have approached this honorable court, the honorable your lordship have granted bail to accused number 2, and
accused number 2 and 2, there is no allegation in the complaint. Against you there is an allegation. Then your own daughter has given a statement.
My lord, in their statements also nothing is brought out, my lord.
No, but suppose if it is released, there is a threat of that witness. It is your own daughter. You may tutor your witness, is it not?
My lord, till today my daughters, he is only seeking the anticipatory bail to look after those children, my lord. No one is there to look after them.
For 2 years they are there.
My lord, any
grandfather is there.
My lord, he is aged about more than 60-65 years, my lord.
But see the statement of your daughter, Mr. Daughter and son also given.
My lord, it is a clear-cut UDR case, my lord. After that, this 306 has been registered, my lord. My lord, any stringent condition may be imposed. He is ready to obey.
Yeah, yes, Mr. Gurraj.
My lord, in this case, the petitioner counsel was submitting that without any reason they have harassing the deceased, my lord. Then admittedly, it is complaint is in version of the complaint is before the prior to death of the deceased. She was so many times she was stated before her parents, brother. ವಿನಾಕಾರಣ ನನಗೆ ಕಿರುಕುಳ ಕೊಡ್ತಾ ಇದ್ದೇನೆ.
What is the ವಿನಾಕಾರಣ? What is the reason?
What is the reason? ವಿನಾಕಾರಣ ಮೇಲೆ because of still he was at the time of the incident. Till today he was absconding, man. It was known that after the arresting of this accused, the investigation officer collected the interrogation to this petitioner On what reason this is what dead, my lord. Even till today he was absconding, my lord. Moreover, my lord.
Yes, Mr. See, you require for investigation that you are absconding from last 2 years.
My lord, anyhow, charge sheet has been filed, my lord.
Charge sheet has been filed stating that absconding.
My lord, if I am having the nature of absconding person, I might not have approached this honorable court by seeking this anticipatory bail, my lord.
You see that charge sheet, it has been mentioned that absconding.
Yes, my lord, I do agree, my lord.
Yes.
Kindly by imposing any stringent condition, my lord.
The problem is that threat to your children, Mr. When they have given a witness against you.
My lord, I am not able to explain how I can explain. Those kids are with me, my lord. I am the only person to look after them. And their statement, once they have stated.
Better you have to surrender and seek for a regular bail. Otherwise, any observation made here, it may affect your things also, 439.
Kindly by imposing any stringent condition, my lord.
That Mallikarjun Saukar is not there now.
No, he is not. I'm the SGP, my lord.
Now you are.
At present, he was not SGP, my lord.
Yes.
Gururaj V. Asilkar, my lord, SGP.
Have you filed an objection?
Already filed, my lord. Even my lord, as per post-mortem report also, it was support to all the material object and the version of the complaint, my lord. The cause of death, it was support to the version of the complaint, my lord.
Oh, cause of death, it is there. There is no doubt that
he was hanging.
Hanging. There is no dispute that.
Yes, my lord.
Is there any abatement?
Nothing is there.
There is no abatement, my lord, because of Finakarana Kudukula Kurta Italian and Ganda. At that, they have so many times they have told to the brother, father.
For what reason, Vinakarana? What reason?
Even also petition in grounds, they have not any single grounds, they have not the cause of death. There is no reason. They have not stated. The duty of the husband is that house was dead. Whether any disease, whether any natural death, they are single, they are not ground as not mentioned.
My lord. Marriage took place since 15 years back, my lord.
No, that statement of your daughter is that you are giving an harassment and ill treatment from the day one.
My lord, if that is the case, she might have lodged a 498 case, my lord. Since 15 years, it can't be imagined without giving any complaint before the competent authority or elsewhere.
Now, what about the trial, Mr. Raj?
Trial court information that it is a petitioner advocate is known that he was from trial.
It is yet to be committed. Yet to be committed, my lord.
It is not yet committed.
No.
Just why?
Due to non-appearing the petitioner, my lord.
So till he accused is absconding, they cannot be committed.
My lord, if he is enlarged on bail, he will cooperate.
Yes, this thing, Mr. Absconding.
What will be the fate of those 5 small kids, my lord?
But you should have realized when you are harassing your wife.
Nothing is there, my lord. It is a false case. If at least there should be any specific allegation against me, my lord.
If that would be the case, why that your children has given statement, Mr.
My lord, those statements, if carefully scrutinized, once they have stated, my father and my grandfather given harassment. Later on, they changed the version. only my father have harassed my mother. And once they have stated, my mother have committed a hanging with sari. And in their further statement, they have stated, my mother.
You have produced all that statement.
Yes, my lord. In my charge sheet, I have published.
Yes. Any of that yesterday it has been received.
Yes, ma'am.
You will have it on Monday 2:30. I will go through that statement also. I have not seen that.
Yes, madam. Very much.
You also see that statement and make out case, Mr. Gurraj.
Please, madam, please. Oblige.
How it will affect that trial?
Please.
Yes, at the request of parties, release this matter on Monday 2:30. Monday 2:30.
Oblige, ma'am.
2:30. Either way, we'll decide it, Mr. You also this thing assist the court, Mr. Gurraj.
Please, madam.
Yes, you go through the records and make a submission.
Please.
Yes, Monday 2:30. Yes. Yes, we'll complete and we'll come back. Pass on. You want to time? ಅವರೇನ 30,000 ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ, 30,000 ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಶಿವ. ಎಸ್ ಮಿಸ್ಟರ್ ಪ್ರದೀಪ್, ಯು ಕ್ಯಾನ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ 50,000 ಇಂಟ್ರೆಸ್ಟ್ ಗ್ಲೋಬಲ್ ಕೊಡಿ ಅಂತ. Sri Raju, yes, learned counsel appearing for the claimant has contended that due to that extent, the claimant has suffered grievous injury. He was inpatient for a period of 8 days. He has suffered lot of pain during the treatment. He has spent 92,203 for medical expenses. The global compensation awarded by the tribunal, 1 lakh, is on lawyer side. Hence, he sought for enhancement of compensation. For contra, Shri Shivanegowda, learned counsel appearing for insurance company, has contended that the injuries suffered by the claimants are minor in nature. He has not examined the doctor. Considering that medical bill and wound certificate, the tribunal has granted a just and reasonable compensation. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Peruse judgment and award. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 29/5/2013 due to rash and negligent driving of driver of lorry bearing registration number KA25D 4824. Due to that accident, the claimant has suffered. Where is that injury has been extracted? Suffered. Has suffered zygomatic fracture of ribs. Zygomatic fracture of lateral wall of left orbit, fracture of left zygomatrix, and fracture of 2 lateral end, 3rd, 4th, 5th, 6th, and 8th ribs on right side of the chest. He has spent, as per that medical bill exhibit P10 and P11, he has spent 93,208 rupees for medical expenses. Considering the same, I am of the opinion that In addition to that compensation awarded by the tribunal, 50,000 has been awarded with 6% interest. Accordingly, the appeal is disposed of. With interest. Yes. Password is the one. Password.
$44, my lord. Serial number 44.
Serial number 26.
What is this? Huh? Hmm. Hmm. Serial number 26 ala case of death. What is the date of the accident? 15,000 ತಾಂಡಿದಾರಾ? Future prospect ತಾಂಡಿಲ್ವಾ? What is the age? 21 years. ಅಂದ್ರೆ 40%. Conventional head ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? Interest? Yes. Shri. Yeah. Yes. Yes. Shri Raghu, learned counsel appearing for that claimant has contended that at the time of the accident, deceased was earning as a ಏನಾಗಿ was earning 21,500 as an assistant manager in private company. In documents hakidra. To that effect, he has produced exhibit two copies of the pay slips. In spite of that, the tribunal has assessed the notional income of the deceased as 15,000. 15,000 per month is on lower side. He further contended that in view of judgment of apex court in case of Pranay Sethi, the 40% of the income of the deceased has to be added for future prospects. Lastly, he has contended that in view of judgment of apex court in case of Magma, the claimants are entitled 40,000 each. Hence, he sought for enhancement of compensation. Per contra, the Pradeep learned counsel appearing for insurance company has contended that even though the claimant has claimed that he was earning 21,500 per month working in private company, except producing the salary slip, he has not examined that employer to prove the same. Therefore, the tribunal has rightly assessed the notional income of the deceased as 15,000 per month. He further contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, Perot's judgment and award. It is not in dispute. What is the name of the deceased? Isha Alam alias Alam Ishan has died in road traffic accident occurred on 24/11/2019. Even though the claimant has claimed that deceased was working as an assistant manager in United Sustainable Development Private Limited, Bangalore, earning 21,500. except producing the payslip as exhibit P7 to P11, they have not produced any documents to prove that he is getting salary of rupees 21,500 and not examine the employer. Therefore, tribunal has rightly assessed the notional income of the deceased as 15,000 per month. In view of judgment of apex court in case of Pranay Sethi, 40% of the income of the deceased has to be added for future prospects. Since deceased was a bachelor, tribunal has rightly deducted 50% of the income of the deceased for personal expenses. The multiplier applicable to the age group 21 is 18. Accordingly, loss of dependency has been reassessed as follows. In addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of Nagma, the first claimant is entitled. Sister. First and second claimants are entitled 40,000 each for filial consortium. The claimant number 3 is entitled 40,000 for love and affection. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. The insurance company is directed to deposit the entire compensation amount with interest within 6 weeks from date of disbursement. Memo filed for dispensation of notice to R1. Notice to R1 is dispensed. Yes, Mr. What is this, Mr.
My lord, what happened? You will ask me kindly see page number.
Yes.
Page number, my lord, 11 to 13. I have produced the judgment of the.
Yes.
That is in MFA 1051 bar. My lord, 1051 bar 2016.
Page number?
Page number, my lord, 13.
Yes.
This is the appeal filed by the APSRC challenging negligence and quantum of compensation. Wherein, my lord, for the respondents, my lord, the claimants, Mr. Gopalakrishna appeared. And this case was disposed of by the judgment dated 5th March 2018. After contest, and my lord, you ask me kindly turn para 12 of the judgment. Para 12 of the judgment at page 21.
Yes.
My lord, the learned counsel on behalf of the respondent and the claimant have vehemently argued and disputed the contention urged by the learned counsel for the appellant and corporation and contended that the police on registration of the case so and so. And this is regarding their contention, my lord. The finding.
Wait, let him complete. I'm not passing any order. Yes.
And
wait,
this honorable court has my lord, this honorable court has considered their contention at para 12, 13, and 14. Then, my lord, the finding, my lord, you ask me kindly see para 18 of the judgment.
No, as on that day, this appeal was pending. Yes. 2016.
Howdo. But
then
I
why
have not
this has
appeared
not
in
been brought to the notice of the court?
You should have brought by them because I have not filed wakalat. I have filed wakalat only after disposal by your lordship.
Yes, then
I was
you
not
have
at all knowing. Then you lost me. Then my lord, you lost. Para 18.
Not in the question of law. You have suppressed. I will impose the cost, mister. If you say like that, when there is an appeal filed by that this thing, insurance company in respect of the same, it has not been brought to the notice of the court. Already, Why you have not brought to that court when that insurance company appeal is argued that there is an appeal filed by you? You yourself as a counsel. Then why you have not brought to that notice when that earlier insurance company appeal has disposed of? Yalla case allo nam connected matter ide anta heltir. Why you have not brought to that? Same counsel. Then you are arguing that the ground that there is no error, there is no ground. I will see how that error. This is not, Mr. There should be an affair. Why delay? What is your conduct, Mr.? When you have not brought to the notice of the court when earlier disposed of, same counsel. If there is an other counsel or yes, your appeal, you should you not brought to that notice? Nim appeal or he has not filed an wakalat. He might not be aware. ಆಮೇಲೆ ಗೊತ್ತಾಗಿದೆ ಅವರಿಗೆ ಸೇಮ್ ಕೇಸ್ ಅಂತ ಬಿಟ್ಟು. See, when you are argued before Justice B.A. Patil, you know that you have also filed an appeal. Should you not brought to the notice of the court? ಅದನ್ನ ಹೇಳಿ, ಅದ್ ಬಿಟ್ಬಿಟ್ಟು ಡಿಲೇ ಎಲ್ಲ ಅಂತ ಅಂದ್ರೆ I will grant time. If you want to argue on the merit, I will see. See, all the time we'll trust the advocate. Whatever advocate says is, sometime I will not open the file because we trust that counsel saying that they are fair to that court. Yes. ಗೊತ್ತಾಗಿಲ್ಲ, ನಮಗೆ ಸುಮಾರು ಕೇಸ್ ಇರ್ತವೆ, ಏನೋ ಆಯ್ತು ಅಂತಂದ್ರೆ ಇಟ್ ಇಸ್ ದೇರ್. ಯು ಕಾಂಟ್ ಸೇ ದಟ್ ಎವ್ರಿ ಟೈಮ್ ಪರ್ಪಸ್ಫುಲಿ ಯು ಡಿಡ್ ಇಟ್, ಬಟ್ ದ ವೇ ಯು ಆರ್ ಮೇಕಿಂಗ್ ದಟ್ ಸಬ್ಮಿಷನ್ ಯು ಹ್ಯಾವ್ ಟು ಸೇ ದಟ್ ಆಯ್ತು ಇಬ್ರು ಅಪಿಯರ್ ಆದ್ರೆ ಏನು. ಯೂಶುವಲ್ ಆಗಿ ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿಲಿ ಅವರಿಗೆ ಡೈರೆಕ್ಟೆಡ್ ಟು ಟೇಕ್ ನೋಟಿಸ್, ಡೆತ್ ಕೇಸ್ ಅಂದ್ರೆ ಟೇಕ್ ನೋಟಿಸ್ ಅಂತ ತಕ್ಷಣ ಅವ್ರು ಆಯ್ತು ಸ್ವಾಮಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅವರಿಗೂ ಗೊತ್ತಿರೋದಿಲ್ಲ. ಬಟ್ ಯು ನೋ ದಟ್ ದೇರ್ ಇಸ್ ಅನ್ ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ ಅಪೀಲ್ ಬಿಕಾಸ್ ಸೇಮ್ ಕೌನ್ಸಿಲ್ ಬೇರೆ ಬೇರೆ ಆಗಿದ್ರೆ ಇಟ್ ಇಸ್ ಡಿಫರೆಂಟ್. Yes, you verify.
Delay may be condoned and may not. For as far as other respondents is concerned, the Gopalkrishna is appearing for them.
Yes,
There
yes.
is no necessary to take steps.
Yes.
He may be.
What about the non-furnishing of who is R1?
Same claimants only. Claimants, both wife and husband.
You will take notice for R1. Yes, yes. I have a granted in a stay.
Illa madam, your Rashmi kindly grant stay.
I will grant that interim order. You take your own time. Yes. Bad. You have no instruction. You get an instruction. Yes. Heard on IA 2 of 2021. That impugned the judgment dated 5th March 2018. A judgment in MFA 1051 of 2016 was passed. Review
29, page number 29, madam.
Yes, yes.
Page number 29.
The judgment and award passed in MFA 4919 of 2016 on 11th April 2019 in respect of the very judgment and award passed by the tribunal. The insurance company has filed an appeal. It was disposed of on 5th March 2018. The same has not been brought to the notice of this court when disposing of that MFA 4919 of 2016. In view of the above, order dated 11th April 2019 passed in MFA 4919 of 2016 is stayed till next date of hearing.
ಅಲ್ಲ until further ಅಂತ ಆಗಿ next time ಅರ್ಥ ಹೋಗ್ಬಿಟ್ರೆ ಕಷ್ಟ ನಂಗೆ.
Yes, yes.
Until
yes. ಆಯ್ತು ಬರ್ಲಿ.
Please my lord. Next week my lord. Next week.
Yes. No, they want to file an objection to that. Let him file.
Please my lord. Please.
You pay the process for R1.
ಅಲ್ಲ ಅವ್ರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ರ ಗಂಡ ಹೆಂಡತಿ
No, he has no instruction, mister. He has no instruction to take. Yes.
ಅಲ್ಲ at least let Mr. ಇವರು ಗೋಪಾಲಕೃಷ್ಣ ಹೇಳಿ ಅಂತ ಇವ್ರು ಗೊತ್ತಾಗಿಲ್ಲ. You can notice.
No, unless he voluntarily take, I can't insist, mister.
Please, man, I'll pay. Allah, process and to other sooner delay ಆಗ್ಬಿಡುತ್ತೆ ಅಂತ.
Week's time is granted to pay the process. to issue notice to R1.
Please, my lord.
ನಾನೇನ್ ಸದ್ಯಕ್ಕೆ ರಿಟೈರ್ಡ್ ಆಗಲ್ಲ ಬಿಡಿ. Till then it will be there. Yes. Yes. Contributory negligence. Huh? Then matter requires to be heard. You are insisting for 20% has to be reduced. Then we will hear. Next week. Yes. Heard. Admit. Post for hearing on 30th. Yes. What is this, Mr. Pradeep? Complaint and evidence says they are not boarded. They even their evidence is they want. ಅಲ್ಲ ಅದನ್ನ ಈಗೇನ್ ಮಾಡಿದಾರ ಅದು ಹಿಂಬದಿಯಲ್ಲಿ where is that ಇದು FIR is registered on the same day. ಅಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಲಾಡ್ಜ್ ಮಾಡಿ ದಿನನೇ FIR ಹಾಕಿದ್ದಾರೆ. ಇಬ್ಬರು ಕೂಲಿ ಕೆಲಸಕ್ಕೆ ಕರೆದುಕೊಂಡು ಹೋಗುದು ಟೆಂಪೋ ಹಿಂಬದಿಯಲ್ಲಿ ಹತ್ತಿಕೊಂಡಿತ್ತು. ಅದೇ ಸಮಯದಲ್ಲಿ ಟೆಂಪೋ ಚಾಲಕನು ಟೆಂಪೋನು ರಿವರ್ಸ್ ತೆಗೆದುಕೊಳ್ಳಲು ಏಕಾಏಕಿ ಹಿಂದಕ್ಕೆ ಚಲಿಸಿದಾಗ ಟೆಂಪೋ ನಿಂತಿದ್ದು. ಹತ್ತಿಕೊಂಡಿದ್ದು ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಐತೆ. ಎಲ್ಲಿ ಆಯ್ತ್ರಿ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಫೀಸರ್ ನ ಯಾರನ್ನಾರು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದೀರಾ? ಏನು ಆಯ್ತು, ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಆಗಿರ್ಬೋದು. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಫೀಸರ್ ಅಲ್ಲ ಆಯ್ತು, ಪೊಲೀಸ್ನವರು yes, who is other side will admit it. Yes, heard, admit.
Serial number 59.
Yes, none appear. We'll list this matter next week. Same next week. Yes. Bernard Council for the appellant has submitted that this appeal may be called along with the own next week. Yes, Srinivas. None appear. Release this matter of 2 weeks. Oh, Mahesh.
Yes, madam.
ಮಹೇಶ್ ಯಾವ್ದ್ರಲ್ಲಪ್ಪ?
70, my lord, I am ready.
ಯಾವ
70.
ಕೇಸ್ 72 70 minus other side is not there.
Okay, man.
70 li respondent none appear for respondent.
Please.
Yes, after 2 weeks. Yes, ma'am. No, what is this, mister? ಅವ್ರು ಏನಕ್ಕೆ ಹಾಕಿದ್ದಾರೆ ಇನ್ಸೂರೆನ್ಸ್ ಓನ್ಲಿ ಕ್ವಾಂಟಮ್. ಎಸ್, ವೇರ್ ಇಸ್ ಇಂಜುರಿನಾ ಡೆತ್? ಲೈಬಿಲಿಟಿ ಅಂತ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. The judgment of the tribunal holding so else that not appreciated the evidence, documents and error in granting the use compensation. Criminal outlaw has seen that private tax producing the income tax clearly demonstrates that there is no loss of income after the accident as getting income. So, criminal has granted the use compensation of the loss in the later period. Only quantum. Petitioner got examined the Mahesh evidence a petitioner to commence the hospital notice so and so recently whole body disability so and so 10% for the purpose of computing the compensation under the loss of future income 10% ತಾಂಡಿದ್ದಾರೆ. 47 towards the right lower limb and 16 towards whole body. ಡಾಕ್ಟರ್ 16% ಹೇಳಿದ್ದಾರೆ. Disability of 47% towards the right lower limb, 16% whole body. 16 ಇನ್ಕಮ್ ಎಷ್ಟು ತಗೊಂಡಿದಾರಪ್ಪ? ಇನ್ಕಮ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? ಇನ್ಕಮ್ where is that income tax return? ಅಲ್ಲ ಎಷ್ಟು ಎಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ? ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಇನ್ಕಮ್? ಆಮೇಲೆ ನಿಮಗೆ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಫೈಲ್ ಮಾಡಿಲ್ವಾ ನೀವು? ಆಫ್ಟರ್ ದಟ್ ಎಷ್ಟಿದೆ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್? ಮತ್ತೆ ಏನ್ ಲಾಸ್ ಆಗಿದೆ ನಿಮಗೆ? ಅಲ್ರಿ ನಿಮ್ ಇನ್ಕಮ್ ಏನು ಕಡಿಮೆ ಆಗಿಲ್ಲ ಅಲ್ಲ, ಅಷ್ಟೇ ಐತಲ್ಲ. ಅಲ್ರಿ ನೀವು ಪರ್ಸನಲ್ ಆಗಿ ಸೂಪರ್ವೈಸಿಂಗ್ ಆಸ್ ಎನ್ ಸೂಪರ್ವೈಸರ್ ಅಗ್ರಿಕಲ್ಚರ್ ಇದ್ರಲ್ಲಿ ನಿಮ್ ಅಗ್ರಿಕಲ್ಚರ್ ಇನ್ಕಮ್ ಏನು ರೆಡ್ಯೂಸ್ ಆಗಿಲ್ಲ, ನಿಮ್ದು ಇನ್ಕಮ್ ಅಷ್ಟೇ ಇದೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರ. ಅದು ಅವಾಗ 33,000 ರೂಪಾಯಿ ಹೆಂಗ್ ತಗೊಳಕ್ ಬರ್ತದೆ? ಇಫ್ ಯುವರ್ ಇನ್ಕಮ್ ಇಸ್ ನಾಟ್ ರೆಡ್ಯೂಸ್ ಬಿಕಾಸ್ ಆಫ್ ಯುವರ್ ಡಿಸಬಿಲಿಟಿ, ನೀವು ಆಕ್ಸಿಡೆಂಟ್ ಹಾಕಿದ ಮುಂಚೆನೂ 33,000 ತಗೊಂತಾ ಇದ್ರಿ, ಆದ್ಮೇಲೂ 33,000 ತಗೊಂತಾ ಇದ್ರಿ ಅಂದ್ರೆ ನಿಮಗ್ ಮತ್ತೆ ಯಾಕೆ ಟ್ರಿಬ್ಯುನಲ್ ಅವರು ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಕೊಡ್ಬೇಕು? 2,80,000 ನಿಮಗೆಲ್ಲ ಲಾಸೇ ಆಗಿಲ್ಲಲ್ಲ. 33,000 ನೀವು ಅವತ್ತಿಂದನೂ ದುಡಿತಾ ಇದೀರಿ, ಇವತ್ತಿಂದನೂ ದುಡಿತಿದ್ದೀರಾ. ನೋವು ಆಗಿದೆ, ಆಮೇಲೆ ಹಾಸ್ಪಿಟ್ಲ್ ಖರ್ಚಾಗಿದೆ, ಕೊಡ್ಬೋದು. ಲಾಸ್ ಆಫ್ ಎಮ್ಯುನಿಟೀಸ್ ಎಷ್ಟಿದೆ? ಎಮ್ಯುನಿಟೀಸ್ 20 ಇದೆ, ಅದು ಜಾಸ್ತಿ ಕೊಡ್ಬೋದು. ಬಟ್ ಇಲ್ಲಿ 2,80,000 ಕೊಟ್ಟಿರೋದು ಡ್ಯೂರಿಂಗ್ ದ ಲೈಡರ್ ಪೀರಿಯಡ್ 33,000 ಲೆಕ್ಕದಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರು. ಆಯ್ತು, 3 months ನಿಮಗೇನ್ ಲಾಸ್ ಆಗಿಲ್ಲಲ್ಲ. 3 months There is no loss, mister. ಈ ಕೊಟ್ಟಿರೋದೇ ಜಾಸ್ತಿ ಅಂತ ಅವ್ರು ಅಪೀಲ್ ಹಾಕಿದಾರೆ, ಅದಕ್ಕೆ ಏನ್ ಹೇಳ್ತೀರಾ ಅಂದ್ರೆ ನೀವು ಅಟೆಂಡೆನ್ಸ್ ಚಾರ್ಜ್ ನಿಮ್ಗೆ ಅವ್ರ ಕೇಸು ಡಿಸ್ಮಿಸ್, ನಿಮ್ ಕೇಸು ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ ಯು ಆರ್ ಲಕ್ಕಿ ಬಿಕಾಸ್ ದಟ್ ವಿಲ್ ಬಿ ರಿಟೈನ್. ಯು ಆನ್ಸರ್ ದೇರ್ ಕೇಸ್, ದೇ ವಾಂಟ್ಸ್ ಅ ರಿಡಕ್ಷನ್. ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ಅನ್ ಅಪೀಲ್. 1 ಲಕ್ಷ ರೂಪಾಯಿ ಲೇಡರ್ ಪೀರಿಯಡ್, 3 ಲಕ್ಷ ರೂಪಾಯಿ ಲಾಸ್ ಆಫ್ ಫ್ಯೂಚರ್ ಅರ್ನಿಂಗ್ ಹ್ಯಾಸ್ ಬಿನ್ ಕೊಟ್ಟಿದ್ ಜಾಸ್ತಿ ಅಂತ ಅವ್ರ ಕೇಸ್. ನಿಮಗೆ ಬೇರೆ ಎಲ್ಲಿ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿದ್ರು 3 ಲಕ್ಷ ಅಡ್ಜಸ್ಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ. We have to reduce. Yes, anyhow, he is not there. Yes. Keshav Prashant, Learned Counsel for the appellant is not there. Then appear for appellant in MFA 5055 of 2019. Hence release this matter. Ele kodi. Execution file madi. You file that execution. 50% entire compensation amount interim tribunal on or before 4/12/2019. If it is not deposited, there is no interim order in file an execution. Avag bartare. Yes. Yes, Pradeep. What is this, Mr. Pradeep? ಅಲ್ಲ, ಓನರ್ has to pay. ಓನರ್ has represent ಮಾಡಿದಾರಾ? ಯಾರು ಬಂದಿದ್ದಾರೆ ಓನರ್? ಮಾಡಿ. No, he said it can be disposed of. Yes. Elide finding of the tribunal. Accident occur, rash and negligence. The policy issued for a private car liability only. However, respondent number 3 has not produced that original policy to show that it is issued only for the private car liability. Hence, that contention for respondent number 3 cannot be accepted. Therefore, the respondent shall indemnify the first respondent ಅಂತ ಹೇಳ್ತಾರೆ. ಹೆಂಗೆ ಅದು ಪಾಲಿಸಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರ್ಲಿಲ್ವಾ? Not produce the original copy to show that it is received only for the private car policy. ನೀವು ಹಾಕಿದ್ದೀರಾ? ಪೇನ್ ರಿಕವರಿ ಬರಲ್ಲ ಇದರಲ್ಲಿ. ಡ್ರೈವರ್ ಲಯಬಿಲಿಟಿ ಇದೆ. 100 ರೂಪೀಸ್ ಏನ್ ತಗೊಂಡಿದ್ದೀರಲ್ಲ, ಓನರ್ ಕಮ್ ಡ್ರೈವರ್ 100 ಒಂದು 50 ಬೇಸಿಕ್ ಪ್ರೀಮಿಯಂ. ಡ್ರೈವರ್ ಓನರ್ಗೆ ಥರ್ಡ್ ಪ್ರಾಪರ್ಟಿ ಡ್ಯಾಮೇಜ್ ಬಂದೇ ಬರುತ್ತಲ್ಲ. ಲಿಮಿಟೆಡ್ ಲಯಬಿಲಿಟಿ ಅಂಡರ್ ದಟ್ ಅಲ್ಲ, ಥರ್ಡ್ ಪಾರ್ಟಿಗೆ ಇದೇನ್ ಬೇಡ, ಆಟೋಮೆಟಿಕ್ ಅದು. ಅಲ್ಲಲ್ಲ, ಥರ್ಡ್ ಪಾರ್ಟಿಗಾದ್ರೆ legal liability to the driver, basic premium, legal liabilities. Yes, yes, mister. Putting judgment up. ಯಾರ ಮುಂದೆ ನಮ್ಮಂದೆ ಬನ್ನಿ. Scooter on account of rash and negligence driving the scooter. Yes. Yes, Mr. That's all. Yes. ಎರಡು ಅಪ್ಪೀಲ್ ಏನಕ್ಕೆ ಮಿಸ್ಟರ್ ಇಬ್ರು ಇನ್ಮೇಟ್ಸ್ Sri Pradeep, Learned Counsel appearing for the insurance company has contended that the policy issued by the insurance company for a private car liability only. There is no additional premium has been collected since the climate in the deceased in MEC 1699 of 2017 and climate in MEC 1700 of 2017 are the inmates of the car. The insurance company is not liable to pay any compensation. The tribunal, even though the policy has been marked as exhibit R1, the tribunal has given a finding that no policy has been produced. This finding of the tribunal is perverse, contrary to the material available on record. In support of his contention, relied on judgment of Apex Court 2008 ACJ 2045 and 2013 1 SEC 731. The owner of the offending vehicle is served unrepresented. Sri Girish B. Baldare, Learned Counsel appearing for the claimant, has contended that since the claimant is third party, it is for the insured and the insurance company. He contended that the tribunal, after considering that material available on record, has passed just and reasonable compensation. Hence, he sought for dismissal of the appeal. Heard the Learned Counsel for the parties, peruse judgment and award. It is not in dispute Pushparaj died in road traffic accident on 2/4/2017, and Chandrakala is suffered an injury. The Pushparaj died in accident. The Pushpakala is suffered an injury. The Chandrakala is suffered an injury in a road traffic accident occurred on 2/4/2017 due to rash and negligent driving of driver of car bearing registration number KA 51 MD 3870. The tribunal, after considering that evidence on record, has held that the driver of the car bearing registration number KA 51 MD 3870 is negligent in causing the accident. That finding of the tribunal has not been challenged by the driver or owner of the car. Only point which has been raised in this case before this court by the insurance company is that the insurance policy issued by the company for a private car liability only, no extra premium has been collected. The insurance policy has been marked as Exhibit P1, Exhibit R1. It is very clear that they have collected basic premium of rupees 2,237 plus 50 rupees for legal liability to the driver and 100 rupees for owner cum driver. Owner driver. Owner himself was driving that. Any other loading discount? Yes. They have not collected any extra premium for inmates. Therefore, the insurance company is not liable to pay that compensation. In this aspect, the apex court paragraph 10 mark market. The judgment ಹಾಕಿದ್ದಾರೆ ನಮ್ಮದು. Pencil ಅಲ್ಲಿ mark ಮಾಡಿದ್ದು next extract ಮಾಡಿ 11 10 11. The tribunal, next paragraph, has failed to consider this aspect of the matter. Therefore, the finding given by the tribunal that the insurance company is to indemnify the owner of the offending vehicle is unsustainable. The same is perverse, contrary to material and records. A judgment extra. In view of the above, the finding of the tribunal, the insurance company is liable to indemnify the owner of the offending vehicle is set aside. The finding is unsustainable. Hence, the same is set aside. In respect of other aspect is concerned, it is confirmed. Accordingly, appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. The respondent number 1. ಇಲ್ಲಿ ಎಷ್ಟನೇ respondent? Owner. Yes. Respondent number 1. What is his name? ಅದೇ ಚಂದ್ರಕಲನ ಅಲ್ಲ ಚಂದ್ರಕಲಾ ಸುಜಾತ. The owner of the offending vehicle, Sujata, who is respondent number 1 before the tribunal, is directed to deposit entire compensation amount with interest within 6 weeks from date of receipt of copy of the amount in deposit may be directed to refund to that insurance company after due verification.
Your Lordships, kindly, my lord, serial number 44, my lord. This your Lordship has passed an order.
Yes.
My lord, in this case, my lord, your Lordship has already passed an order of stay until further order by your Lordship order dated 22/3/2021.
ಯಾವಾಗಲೇ ಇತ್ತು ಅದು stay ಬೇಡ. I thought I was just recollected. Yes, there was an entry order.
Yes, my lord. Sorry, my lord. I'm not able.
Review one.
Stay is already there. But in the cause list they have shown, I also misled.
Yes, yes.
In the cause list, they have shown it as a stay.
ಅಂದ್ರೆ ಅಯ್ಯ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಅಂತ ಹೇಳಿಲ್ಲಲ್ಲ, ಹಂಗಾಗಿ
Mostly.
ಅಯ್ಯ ಡಿಸ್ಪೋಸ್ಡ್ ಅಂತ ಹೇಳಿದ್ಯಾ ಆರ್ಡರ್ ಅಲ್ಲಿ?
ಇಲ್ಲ ಇಲ್ಲ,
ಹಂಗಾಗಿದೆ.
ಹೇಳಿಲ್ಲ.
ಏನೋ ಅಂಟಿಲ್ ಫರ್ದರ್
ಅಲೋಡ್ ಅಂತಿದೆ, ಅಲೋಡ್ ಅಂತಿದೆ, ಐ ಇಸ್ ಅಲೋಡ್ ಅಂತಿದೆ.
ಮತ್ತೆ ಯಾಕೆ ಅಯ್ಯ ತೋರಿಸ್ತಾರೆ?
ಐ ಇಸ್ ಅಲೋಡ್.
Then it is a mistake of the office.
Yes, my lord. Much obliged.
ಏನಾಯ್ತು? I think we can't none appear, then we have urgent. Next week. Next Friday. That's correct. Next week ಅಂದಿದೆಲ್ಲ. Further orders. Orders. IA is allowed ಅಂತಿದೆ. Next week, Mr. Rana. Yes. ಅದು only week's time is granted to pay the process.